right. Welcome everybody. Happy Friday to all of you. It is Friday, March 22nd, almost the end of March and almost into the month of April, which is terrifying in and of itself. Glad to see you guys here.
I had that same feeling just a little bit ago. I was like, oh, crap.
Oh, yeah. Isn't it scary?
Time just keeps going, doesn't it?
Oh, my gosh. So, interesting show tonight. No, there's not some special magical thumbnail that looks beautiful because I didn't have enough time to put together the information to get to the lovely individual.
Rob was as on time with his show prep as he is with his attendance.
Pretty much. Yeah, that's about right. That actually kind of summarizes it because today was a day of days, man. And this week was a week of weeks. I woke up with counsel in one of my cases decided that they woke up and chose violence. And I was like, well, I'm going to mitigate a little bit, but maybe lay a trap, maybe respond in kind. I
Guys, I'm not litigating against Rob. I mean, I also choose violence, but it's somewhat unrelated.
For those of you who ever wonder if the person on screen that's this very pleasant, happy, jovial individual can ever have like teeth in court filings and in court, I most certainly can. So today was that kind of day. It was interesting. But we've got a lot that happened this week that I have not kept up on. So I'm playing catch up and going over a couple of things that have been dropping. We've got Hannah Gutierrez-Reed filing a motion to basically get her out of jail, a motion that probably should have been argued more appropriately at the time of her surrender to jail.
I mean, they don't even argue at this time. We'll get to that, but I have opinions on their motion. Like to start with, maybe it shouldn't have been called a motion and maybe it should have been called like a movement.
Oh no. Was that a body part reference or anatomy function?
It was a scatological. Yeah, scatological humor. Yes,
scatological. Okay. We've got Baldwin to briefly talk about. I'm going to let Ian take the lead on that one, just recapping the Baldwin motion because that thing is like 100 some odd pages.
Oh, it's ridiculous.
Corey Richins, we just have to talk a little bit about some of the stuff we learned this week on that one. And then Sam Bankman-Fried, the prosecutor's recommendation. Well, I didn't have a chance to go through that. I know that Ian touched on some of it, but I wanted to kind of browse through a little bit more and then see how Sam Bankman-Fried would respond to such a filing.
I covered the most hilarious part, which was
the whole like this is my plan.
It's really lovely when they could just like post his master plan for how to get out of shit. It's like, this
is my plan. I am so smart. This is my plan.
By the way, folks, this is why if your lawyer tells you to like write something down, but mark "for my lawyer" at the top, that it's very, very important that you do that. Yeah.
Maybe don't write stuff in jail all the things.
Well, sometimes you're in jail and you got to write stuff down, and I have had clients like cells searched in situations where it was like, oh yeah, we searched and we found a document, but it was marked "for my lawyer," so we didn't read it. It's like, thank you. That's exactly why that was done.
Rachel Mills asked, did I see that Carly Russell pleaded guilty to false? And I did not. I didn't see that. I know that case was active for a while. I didn't see that was a complete. Vern, Rob, you're too hard on the boy. SBF is misunderstood.
The thing that actually terrifies the crap out of him is that he's perfectly understood. And that is what scares the out of him.
Oh yeah. Well, that's what scares the hell out of me, that someone would just so brazenly. We'll get to it. We'll get to it when we get to it. For those of you who are
middle name, it's Sam Brazen-Fried.
Sam Brazen-Fried. That actually, it's Sam Brazen not so Fried.
Fried is not in his on his calendar.
And it won't be for a little while. So, for those of you curious as to why my background is red, no, we're not code red already. We are red because NC State, we are in March Madness in the United States, where we have the NCAA basketball tournament, which for 1 month out of the entire calendar year, the entire world becomes remarkably interested in college basketball. And NC
Entire world asterisk.
Yeah. NC State was the underdog last night. They were number 11 going against number 6 in the bracket against Texas Tech. And just, it was a mollywhopping. It was 80-67. Lovely game. I watched every minute of it. It was fantastic. It was a 9:40 start time in the evening. Oh, and it was in Pittsburgh, which didn't make sense. Like, why are you starting at 9:40 at night? So we have a law firm bracket. They probably did. We have a law firm bracket going, a little friendly competition among friends and colleagues. And if you guys don't know lawyer humor, we talk a whole lot of trash to each other, like a lot of trash. So my bracket, I am currently number 1 amongst the firm for the prediction scale. So we're doing well. We're doing well so far.
Great casual drop there. Very subtle. No one noticed.
Nobody, not a single person. Nope. And no one notices the big red hat with Mr. Wolf on it. Here's a question. Oh, Karen Reed case.
Sorry, did you say that the mascot is Mr. Wolf?
Oh, I'll get to that in a second. Let me answer this one. What about the Karen Reed case? Ian, hold your comment. I know you have a comment. Karen Reed case. I have not been covering that one. I know that Lawyer has a little bit, and I know there's other channels covering it. I know that it's exceedingly complex and that it involves conspiracy and allegations that are pretty wild. I feel like it's kind of irresponsible for me to jump in at this point without the knowledge and the backstory. So I haven't covered it. I'm going to defer to my other colleagues on doing that. Ian, you can make your joke now about the Mr. Wolf.
Did you say Mr. Wolf?
Yes, Mr. Wolf.
So, like, did somebody ask their toddler to name it, or like?
No. Actually, the mascot is as depicted on my hat. It's the wolf pack, but our formal mascot are actually 2 married wolves. They are Mr. Wolf and Mrs. Wolf. Yes, they are married wolves. We are it's North Carolina. It's Mr. Wolf, Mrs. Wolf.
They had to specify that, so because it's North Carolina, and somebody would get very upset if there was the possibility that these wolves were living in sin.
No, they were married. There's a whole marriage ceremony and everything. It's very cute. It's very cute.
Wait, what?
Don't ask questions you don't want the answer to. But I know. There's a lot of questions. How this one came up. How is Leo? Well,
be careful how you talk about my client.
I have to admit something. And this is kind of embarrassing for those of you who are watching. Leo is good. He's wonderful. He's growing like a weed. He's very active. He is downstairs running like a crazy person with mischief, trying to manage his mischief, and thus incapable of managing mine. We had an interesting experience that caught me off guard like the other week, and I was using the restroom, and dogs are curious creatures. And I was using the restroom as a male, using the restroom and going
as
number 1. No, going number 1. So standing.
Okay.
Legs apart. And Leo was so curious as to what was transpiring that before I knew it, there was a head that like just shot between the legs and was very curious as to what was happening in that toilet bowl.
My client's going to sue.
Did I actually pee on my own dog? Yes, I did. It was a little bit till I could scream and tell him, "Oh my God, no, get out." Oh
yeah, my
my
client's
God.
suing.
Well, you know what? He brought that up on himself. Like there was a.
No, that's your fault.
That's not my fault. It's not my fault. Yes, there was a little bit of pee on the dog's head. I washed him. He was washed. He was cleaned. And then he went back to just chaos. Every ounce of chaos that a little pup could muster. Oh, there's certain things that they tell you about dogs and certain things that you don't remember after you've raised a puppy. Like I've done the puppy raising a couple of times. And I think you kind of block out a lot of the difficult parts because they end
There
up
are no
so
difficult
cute.
parts. It's all pleasant.
Learn to close the door. You should see the size of this damn dog. He's not small there, and he's also really, really damn smart. Like he will figure out how to get in. So puppies are puppies. Oh no, hang on, I just saw one. Oh no, Jewel, I guess Rob can't stop midstream anymore. Midstream because we're streaming right now. I don't know.
I don't think that was what they were referring to.
I don't know what they were referring to. It was a very
You don't
uncomfortable
really?
moment. Well, I do. It was a very uncomfortable moment.
I was gonna say, Rob.
I was
Nobody
very
believes you don't know what they were referring to.
I was very uncomfortable because and then admitting that at large, like to all of you people, like there's got to be other people who've done well, made me feel less bad about this. I mean,
It's okay, Rob. This is a judgment-free zone. As it, as in like weapons free, as in we are free to engage in judgment.
It's free from judgment. That's fair. That's entirely fair. It is also
we don't
painful.
charge for the judgment here. It's available to all.
Yeah. It was interesting. Sorry, missed that. Hang on. The chat's flying so fast. I was trying to catch something. Has he torn down a shower curtain yet? Nobody goes after the regular curtains all the time. Dogs are dogs, man. They're trying to figure out everything that they can. They push boundaries, and especially the willful breeds. They love pushing those boundaries. His poor timing, Rob from Poison Elf. Solid. It's a free judgment zone. It is a free judgment zone. Purple Pineapple caught you live before bed. Yay, watching from the UK. Hey, guys in the UK. Where are you guys tuning in from? How was your week? I kind of want to hear from all of you. I know that there's been a lot going on this week and that I have been a little MIA because a little bit crazy. MB, close the door, lock the door, sit while peeing. Well, can't be perfect all the time. Dr. Kit
I aim for
McGuire.
about 0%.
I love this. Dr. Kit McGuire, PhD. My husband has peed on our cat twice.
Did the cat deserve it, or
don't know? But cats pee on stuff all the time, so I guess it's payback. I don't know. Deb D, Rob, what's the best way to send you an image? I'm concerned at first, but email is probably the best way. lawnlumber@gmail.com is the email address. LJ Peach. Between kids and dogs, I haven't been to the bathroom alone in 40 years. LOL. Yeah, that is definitely a thing. Mischief number 2 likes to sing when he's in the bathroom, any tune that he makes up in his head, and loves to just call you in there all the time. Yeah. Crazy Cat Queen, don't feel bad, Rob. I have a cat that likes to swipe at fluid streams, sink, and hubbies as well. He tried to stick his paw into the toilet before and while flushing. Finally got Hubs to start closing the door. See, maybe it's a guy thing. I don't know. We got Virginia in the house. Virginia is here. I've got hang on. Rosie toasted Jen's stepmother who was passing. I should have waited for a different moment to pull that up, but I feel like I can handle this now. Cheers and toast to Jen's stepmother who is passing. Step parents are difficult because they enter your life at a different stage in your life and they bring different things to your life that maybe you don't understand in that moment, but hopefully they're always impactful and that they give you love and they give their spouse love that creates a happy and healthy household for you to grow up in. It's never fun. or easy losing a parent or a step parent. May they find peace. May they be without pain. And may that passing go with dignity and grace. And may you remember all the good things and celebrate them all the time. Cheers.
Cheers.
Die hard HTTR celebrating my birthday. My son gave me the flu and my mom gave me attitude. Fun times. Moms are there to give you attitudes, and kids are there to give you diseases and sicknesses and viruses. So happy birthday. Enjoy it. Get out and enjoy it. Oh, cats give you no privacy. Cats do pee on stuff. They use a litter pan. Do not pee on stuff. Oh, no. I beg to differ. I have
sometimes cats get very
vindictive.
Yeah.
Yeah. Weird things happening in chat right now. Nabnana7X, my cat licks my legs while I pee. Well, you know, I will
weird
say
things
I went
happening
there
in
first.
chat. He says like he didn't start it.
I was going to say I went there first. KVB Studios. My husband can always find me wherever I am in the house because the dog and the cat are within 5 feet, always trying to work out the two fur balls underfoot, in the face and on the mat. Yeah, that's not an easy thing at all. Katrina Turner, my wolf mix and Bengal rescues work together to get in. Ooh, yeah, they're going to figure that out. I don't care what you do. Mike Labba, Mechanicsville, Virginia, checking in. Champagne there. Champagne indeed. Great way to end the week. Let me see.
I still haven't done a celebration stream for 250.
Oh, you haven't done 250. I haven't done 200K. I have the thumbnail for 200K, but and I'm not going to do that members only. I'm going to read that out loud because it's the disbarment for the person who hired me first.
Oh, yes.
So I am definitely going to do that just live. I think I'm going to pick it next month, like my birthday month. I just try to combine the two. So 200K celebration, and we'll go ahead and read through the disbarment. I might preview it tonight. Who knows? Read like a paragraph from it because it is wild. Tucson, Arizona for Catherine Sink and water. Lori, my dog thinks I'm a walking treat dispenser. And then Cachette, my cat makes eye contact with you.
No, your dog doesn't think you're a walking treat dispenser. Your dog knows that.
But is there anything more that a cat can do than this? Cachette, my cat makes eye contact with you and naughty peas. Like literally makes eye contact and like, yeah, this is happening.
Yeah, that's a cat thing.
Cats will do
Dogs
that.
at least know shame.
Emily Zeke Zelko. For those of you who are new to the channel, a couple of things. Hi, I'm Rob. I'm a domestic relations litigator. I'm a trial attorney in Northern Virginia, and I've been practicing law for more than 13 years. Ian Runkle, the individual that's on screen with me, is a firearms and criminal defense attorney in Canada, has been practicing, well, since the beginning of time, based on his hair and the fact that he is, in fact, an elf. We talk about fun legal facts and topics and go over different things that have happened throughout the week. Ian has a weekly show on Monday. I have a weekly show on Friday. So we like to bookend each other, and whatever story I can't get to, Ian gets to, and whatever story Ian can't finish, I'll get to.
And I like to come in and cause trouble anyway.
Yeah, Ian causes all sorts of chaos because, well, that's what he does. My first job out of law school, I graduated law school in 2010, and they were not hiring lawyers at that point in time. So I was living with my parents for a while, applying to every job that I could think of, and finally ended up finding somebody who was looking for an attorney. The individual that hired me was a solo practitioner from an hour and a half away from my house. So I had to commute an hour and a half to an hour and 40 minutes each way, both every single day.
Turns out there was a reason why they were desperate for people.
The person was a solo who had hung his shingle really prematurely. When I say that, when I first started working, I got a case and I got my first week with his firm. I had to make an appearance for an assault and battery. It was the first return on the assault and battery, which in General District Court in Virginia can go to trial that day. They can just choose to try it. I
Wait,
didn't know any of
seriously?
these things. Oh yeah, you can try it that day. If you consent. If you don't, if you are perhaps an attorney that doesn't know that you should request continuance and request additional discovery time, etc.
Yeah, I mean, they don't do that here.
Yep. So that first appearance was interesting. I've said this story a couple times, where when I was there, my first appearance, the judge goes, "Mr. Morton, do you want a rule?" And I looked at it and said, "Judge, a rule?" And the judge, God bless, the judge looks back and says, "Ms. Morton, do you want a rule that excludes potential witnesses from the courtroom so they can't speak to one another or hear what's being testified to in court?" "Yes, Judge, I would like that, please."
That's a judge who
So,
knows that you're very new and is cutting you some slack.
and he did. And the case went forward.
Good judge. Thank you,
The,
Judge.
the guy was guilty. He was guilty. Wasn't much I was going to do either way. If I had any number of days, weeks, months to prepare, but man, that was rough. And that attorney ended up seeing his practice grow from, I think he like grossed that year, he like grossed 75,000. And then within a year and a half, he had hired me. And then the person who ended up becoming my law partner, who was at that time had just moved from Arizona and hadn't taken the bar yet, was a law clerk. So that firm went from 75,000 in his first year to 500,000 in his second year. Which, when that happens, and by the way, people thinking lawyers make a lot of money. I made $35,000 a year when under my first job. 35,000 a year was my first law job as an attorney.
Which is actually not surprising.
Yeah, but
probably to everybody except Rob
saw the influx of money that the firm had, and made
was somebody who their first
just
lawyer paycheck to their mom, and their mom cried
in sadness or happiness.
Sadness.
Yeah, it can happen.
It was like, we thought you were going to be making money.
That lawyer, I will say something I will never forget. What he told me, he said that he viewed the client trust account, the funds the clients give us to hold in trust as we bill against their trust deposit for a case that we're working on. Right, we're billing against it, hours that we put in on the time, and then we ask them to replenish. That's the standard practice for attorneys to bill hourly. But he viewed the attorney trust account as an accounts receivable. It was money that we had, we just haven't earned it yet.
No.
For anyone who's a lawyer in the chat, that is not how that works.
For anyone who's not a lawyer, the trust money is not yours. It is literally money that you are holding in trust for that person, and you only get to bill it once you've actually done the work.
Exactly. And when you show the client that you've done the work by giving them invoices demonstrating that you've done the work to earn the money.
Yeah, and once you've done the work, then that money becomes yours. But until then, it's the client's money.
Yeah. So Memorial Day of 2012 or Memorial Weekend of 2012, I was scheduled to be out of town, and I had given that employer a hard stop at 3 o'clock because I had to go and catch a flight. And at 3 o'clock, he wanted to call me in for a meeting. And this I had already been discussing with my former law partner, like that we needed to exit and form a firm, bring clients, start doing this the right way. That day, he decided to call a meeting, and the meeting was basically about money. And I was like, you know what? I quit and just left. And what he did after that was really deplorable. He literally went back and reviewed the invoices and readjusted the invoices downward, or readjusted the invoices to bill out more time, so that basically when he cut the check to transfer the money he was holding in trust from his trust account to my trust account, he was so depleted that there was almost nothing left. So what we ended up doing,
real common.
What we ended up doing was we ended up repping a lot of those clients for no fee, like until we were able to clean their case up. That first year hurt a lot.
Yeah, a lot of lawyers are absolute dicks to lawyers who are on their way out.
Yeah. Also, to the extent where he started trying to collect against one of the bankruptcy clients, and we had to bring him in front of the bankruptcy judge. So my law partner and I kind of went about and it's still a motto I love. The best revenge is a life well lived. And I don't know that I like the word revenge. I think people are going to get their comeuppance. Just live your life the best way you can, and don't let that person drag you down. The old saying is, don't wrestle with a pig. You both end up dirty. You both end up rolling in shit, but the pig loves it. 5 or 6 years later, that lawyer did get their comeuppance, and it was in the form of a disbarment. And it was a permanent disbarment, and the permanent disbarment, the readings, just to kind of give you a preview of it, he went to Miami, went to the ABC store to buy liquor, and he bought it with a debit card that was against the firm trust account.
Wait, why would you even have such a thing?
You don't. And then he went to a club and put the debit card for the trust account like down as the whole. This is the tab.
Oh God. Guys, having a like debit card or a credit card that spends off of your trust account is like having a gun that only shoots orphans. There is no use for it that doesn't get you into shit.
Yeah. And then when the
And I don't
trust
mean like
account,
it projects an orphan out the front.
it gets worse because when the trust account went below zero, which
as it would,
was never supposed to ever.
Yeah, except that if you're spending money out of it, like
when the trust account went below zero, the attorney tried to explain, and the attorney actually said in the disbarment hearing, well, that's what the overdraft protection was for.
Why would you even have overdraft protection on your trust account?
You don't. For those of you who ever wonder about this, the client trust account is the scariest thing for any lawyer. For example, when we first set up our client trust account, the bank that we had set it up with hadn't done one of those. It was a local bank we used, and they did what most banks do. They do the fee and interest thing. They added interest. They basically said, here's the interest that this trust account earned, and they put it into the account. Well, the bar goes, no. So the bank had to write a letter to the bar explaining this was our mistake, not the lawyer's mistake. And the interest that went in there, we're going to go ahead and send that to the bar, which that's what you do. It's an IOLTA, interest on lawyer trust account. It's where that IOLTA, all the interest that account earns, spits out to the bar to be used for cases where client relief
one of the ways that like public defenders are funded.
Yeah. So yeah, Lady Drake, I love this. Lady Drake mod in the chat. Trust account that is 1 cent off equals pucker factor.
Oh, it's not even 1 cent off in the direction that you're thinking. I have a video on my channel about one of the worst days I had, and it was that the bank made a bank error in my favor. I had $400 extra in my account because basically I went and cashed a check and the bank credited me twice. But I didn't know that was the reason. It was just we ran the numbers. Like I had an accountant coming in to help with my books because trust account is scary. You got to make sure it's up to date and all of that. And she's like, why do you have $400 that is unaccounted for? And I was like, how is that a bad thing? She's like, well, because this belongs to somebody and it's not you and you don't know who it is. And I was like, gotcha. That is a very bad thing. So we spent ages going through all of my accounts going, where did this mystery money come from? Because that's a big, big problem. And finally we tracked down, oh, right, this mystery money is, I was like, I got one check for $400 in this time. $400 is not a lot of money to, I was like, it's not an amount you typically get. It's a weird amount. So I was like, this
Well,
seems like,
it's great because the reason trust accounts usually get funded by deposits of anywhere from like $1,000 to $10,000. So when we deposit to trust, usually it's that retainer or a re-up on a retainer, and usually lawyers who bill at $200 to $500 an hour are depositing anywhere from $1,000 to $10,000, $20,000, $50,000 at a time. Those are the increments you're used to seeing.
now it's criminal law. So this was somebody who's putting down basically as much as they could whenever they could, right?
Yep.
And that was like, okay, cool. That's fine. But it was really weird to see 2 checks for $400. And I was like, that's gotta be like, it's gotta be a bank error. And my bookkeeper was like, banks don't make mistakes like that. So no. So I called the bank and they confirmed that, in fact, it was, they said, oh, yeah, we credited you twice for the same check. And I went, thank God. Fix it. And they said, well, you can just keep the money.
No.
And I was like,
no.
Actually, I can't. You guys need to make that money go away. And also, I need you to write a letter confirming that this is your fault, because I can be in a lot of crap. And I had to send the Law Society a report to say, hey, I've discovered a discrepancy with my trust account. Here's what the discrepancy was. Here's the attached letter from the bank. Here's all of the documentation. And the Law Society, being absolute dicks, just send back something that says, we have received your report and we'll let you know if we need further information for our investigation.
Yeah.
And I'm like,
no timeline, no anything. They're just like, you can sweat for as long as we want you to.
yeah. And it's just, if they decide that you are not at fault, they just never contact you again, which is in fact what happened. They just never contacted me again about it. But I was like, guys, like, I could really use some closure on this, please. Didn't get any. So yeah, no, that even $400 extra in your account is an absolute, and that cost me way more than $400 because bookkeeper ain't cheap, right? And when you got to have the bookkeeper there all day,
oh yeah,
to try to run this down, like that $400 wrecked me. So I was so pissed.
Lawyers who spend like lawyers who bill, I bill at $400 per hour. Lawyers who bill at $400 per hour will spend, I don't even know how many dozens of hours going back through account statements and invoices and everything. Not billable, not at all. Just hours and hours and hours and hours just to make sure that every penny is accounted for. Because that's your license. That's your ability to keep earning money and to keep providing for people in your firm. So my gosh. But yeah, this guy, like I said, debit card on the trust account, and you gotta get that gray goose. Oh, and every lawyer, and I like this. Natalie Lawyer Chick has a horror story about this. Every lawyer has one of these moments where there's a pucker factor, where they get a question from the bar or something like this. If every single lawyer does, I've never met a lawyer who has ever practiced who hasn't had either a client complain or something where the bar says, can I take a look at this? And the lawyer goes, oh shit. And you almost always it's okay, you have it, you're fine. But it's a scary thing, man. The bar, they put a fear of God into you. Appropriately so, because you're handling very important stuff. So
Hell, I had a guy who sent me to, he wanted to have a file sent to what's called taxation, which is basically they go over your accounts to make sure you billed appropriately. And the funniest thing on that one was that the guy had come in, basically said, I want to hire you, and put down a retainer in trust. And then 2 days later said, I actually found another lawyer I think I like better. Please close my file. And so I didn't even charge the guy a file opening and file closing fee. I just
Mhm.
like, because it was going to be too much of a hassle. So I just refunded the
Closed it out.
entire
Yeah.
amount. I sent it on to his new, like he gave me the name of his new lawyer and I just sent it to them. And what is it? But he still like tried to send me to taxation. So I ended up sending to taxation, like, do I have to attend? This is a zero bill. And they sent back like, no, we're good. We're just closing this file. But that was going to be like an entire day of getting jerked around.
Yeah. It's the bar is, and they serve a very necessary purpose. And I actually kind of like the fact that lawyers are self-regulating because we generally hold ourselves to a pretty high standard and we do our very best to do that. So, but
Except I've got
Tom
a story.
Girardi, that was I saw a bunch of people in the chat like the Girardi School of Law on a smaller scale.
Oh, did you see the video I put up just today?
I wanted you to talk about that separately. So you've got 2 updates that you wanted to give the chat, and I wanted you to give the chat those updates so that I think you're talking about you did a video earlier today, but then you also are probably going to talk about something on Monday that I want you to update the chat on.
I don't think it'll be on Monday. I think I'm going to put a video out, although I'll probably talk about it on Monday as well. Just so
give them an update.
So the update on that is what is it? I put a video out today where there's a lawyer in Canada who the Law Society has just been ordered against their wishes. Like the Law Society does not want to do this, but they've just been ordered that they have to give this guy they have to let him be a lawyer, notwithstanding the fact that he is an admitted child molester. So that's a thing. That's a whole concern. That's a whole big issue. And yeah, the other thing is that there's just been a new drop of Janet documents. So I'm going to be going over those. I'm probably going to do a video and yeah. So
did you have to use the M word? I get it. It is what it is. Chat.
YouTube ain't going to demonetize you over that.
They might. Who cares? Yeah, chat. Don't repeat that because the mods will not let that happen in the chat because YouTube will not like that. But the Janet docs, I want to see the Janet docs. Like, can we do this again? Like, yeah.
Oh, the Janet docs are going to be fun.
Yeah. So we've got a couple of things to cover, but I wanted to start the evening with a I don't know if it's a lighter story, but it was something that usually not in my wheelhouse, and one of the first times I ever get to contribute to Emily D. Baker. So, DUI for Karen Huger. Real Housewives of Potomac star arrested, charged after crashing her Maserati. Well, this is just down the street from me. In Potomac, Maryland, authorities say Real Housewives of Potomac star Karen Huger was arrested after crashing her 2017 Maserati on Tuesday night while allegedly driving under the influence. She was stopped at 11:50 p.m. on Tuesday along Oakland Drive in Potomac. She crossed over a median, crashed into a crosswalk sign, then collided with a parking sign. Well, that's a pretty good indication that the person shouldn't be driving. She was alone in the vehicle at the time of the crash. The damage to her car left it inoperable. Originally, it was believed that Huger was not taking the
crashed into a no parking sign, you said?
Oh, yeah. Well, she parked it there. She was taken to the station where she was arrested, but multiple charges included drunk driving, driving under the influence, driving a vehicle while impaired by alcohol, and negligent driving. Her comment: "Thank you all for your prayers and well wishes during this very frightening experience."
We don't have well wishes if you were driving drunk. Our wishes are stop.
Is this really the take you want to? Is this really what you want to release? That's what she told TMZ. "I'm still in shock from last night's incident, but grateful to be alive today." You should be grateful to be alive. With the passing of my beloved mother, grief comes and goes in waves, and with Mother's Day approaching, it has felt more like a tsunami. Well, I
have opinions.
And then she tries to blame another vehicle, said a vehicle almost struck her and drove off. Well, does that explain the intoxication and driving over a median and hitting a park sign and
I mean, it might explain the driving, but
all of that? Just the tone deaf part of it. What the
isn't
hell?
that like the Real Housewives brand though? Like, isn't that what they do?
I don't know. They get fed alcohol by Bravo apparently, and then they just cause chaos, man. Craziness sells, which is one of the things that I had a rant about earlier today, but I don't want to repeat it. I don't like this. I don't like where we're going. Never mind. I'm not going to do it. Sensationalizing just people that do stupid shit. Like there's cases we cover, Sam Bankman-Fried. We cover the trials. We like to explain the law. Like I like doing that. I really do. I like explaining courtrooms and law to make people feel less afraid of that. But some of the stuff I don't like, the sensationalizing of, like there was a DUI. Like she ran over a median. Almost, she could have killed somebody else.
Oh yeah, it could have been a child.
Easily. Like Mother's Day,
when you
like
drive
what
like
about the
that-
what about the mother of the child that you almost ran over? Like why are we not
Yeah, if
Anyways.
you drive like that, you could very well kill a child.
Yeah. So that was just something where I was like, hey, Emily, you do the Bravo stuff. Look at this. This was in my neighborhood. Okay, Ian, here's a choice. Hannah, Baldwin, Richens, or SBF.
I would say, I mean, SBF is really your jam here.
How quick can you do Baldwin?
Baldwin is long and convoluted because they go through every dispute they've ever had with the prosecution.
What if we
including
did generalized
different prosecutors?
What if we did generalized discussion? Catch the chat up on the issues that are outstanding, not go through pleadings and just kind of say where things stand.
Yeah, that we can do.
Okay.
So they brought a motion to dismiss.
Wait, hang on. Don't new swoop. Baldwin.
Do you have a Leo swoop yet?
Not yet. I have a Leo chaos. Just
because we need a Leo
passive.
swoop.
We do need a Leo swoop. We need one.
So, Baldwin. Baldwin's team brought a motion to dismiss, and in this motion to dismiss, they basically go through every complaint they've ever had with the state. So all of the stuff you've already heard about, like how they got the law wrong, or how they keep talking to the media when they shouldn't. All of those things, they go over literally every one of them again. Because this, which tells me that this probably wasn't something that they thought was going to win, but instead it's something that they think they're going to argue in the media. So that already gets me thinking, like, I'm not super happy with that because
well, it all goes back. It goes back to the procedures in the indictment, and to your point of things we talked about before. Mimi, ouch! Remember, for 2 months, things I'm sick of hearing about. I'm out. Ooh, okay. Well, that's one way to go about it.
We're not going to be on it long, so
not long. I mean, we're going through cases, man. You want to take, you want to take. You don't, you don't. I don't know if you have to announce the departure. That was kind of rough. Anyways, so it goes back to the procedural
not an airline.
Well, it's a procedural element. So when you have someone indicted, you bring them before the grand jury, and the prosecutor brings the case in front of the grand jury with an information. They basically say, grand jury, here is what we are going to allege to you. This is the standard. So grand juries sit in different jurisdictions for a period of time, sometimes 2 weeks, sometimes a month, sometimes 2 months. And they're just common citizens that are brought in to literally hear the prosecutor lay out a case in front of them. and the grand jury determines if they have enough to go forward, and they issue an indictment. So the prosecutor presents the case and says, this is what I would like you to do. Here's the evidence that substantiates that. Please agree with me. And the grand jury says, sure, check mark, and they issue the indictment. There's procedures that you have to follow in getting to the grand jury and what you can and can't present. New Mexico is a very unique state in that New Mexico has actually the ability for the defense to be notified of the grand jury. Oftentimes, defendants are not even notified that their case is being presented to a grand jury. That's the majority of cases. Majority of states don't even allow the defendant to know that the grand jury is proceeding. So,
and
in this
not
case,
only do they get notified, but they also get to send in a letter, which basically says, here is all of the evidence we want presented, the things we think are exculpatory or that might raise defenses. And that is fascinating because, like, I don't know of anywhere else that does that. I spoke to a bunch of, because, I'm not American. So I was like, hey, is this something you've heard of? And they're like, this is not a thing where I am. New Mexico is apparently unique in that regard. So, the main, like, the part of their complaint that isn't just like rehashing old wounds is that they say that basically they gave a bunch of evidence to the prosecution that they wanted presented, like a bunch of witnesses and so forth. And they say the prosecution just ignored that and didn't actually present it to anybody. And so therefore that never went to the jury. And they say, well, maybe the jury wouldn't have returned a true bill, wouldn't have indicted had they had access to all of this. So we think that this should be quashed.
It was interesting because it seemed from my reading of it that her obligations were to read the letter.
And that's going to be the thing, is how much, like, what were her obligations? Because in a lot of places, the Baldwin's team is like, they didn't explain the letter, and it's clear that the grand jury didn't realize that they, that this is what they had to do. And in some places, it's like their witness testified to something at the grand jury and then testified to something differently at Hannah's trial. And it's like, that's not a reason to quash. That's a great reason that would have been something great for Bowles to cross-examine on, for instance. And it's going to be great for Baldwin to cross-examine on. And in some places, they just get super nitpicky. Like, I am sorry, when they say, he says that he's a producer, but he's only ever released one film, and he's appeared on several, but he's only ever released one. So he's not really as much of a producer as that makes it sound. I'm like, we are into the pickiest of nits here.
Exactly.
And
you start getting into the weeds, and the grand jury really isn't tasked to that. The grand jury is tasked with determining whether there are facts that do exist, that are sufficient to reach a probable cause standard for issuing the indictment. Like, you're talking about the bare minimum, which is why when I read this, I was going, okay, procedural faults, fair. I'll give you that. Let's see what they are. And then it was like, she has to read the letter. And then they go on about the different things of the witnesses that they were supposed to call. And I was going, but does she have to? Like, does she have to advocate that case? I don't think she has to advocate the case. She just has to say the options there.
And that's going to be where it becomes interesting, is how much of an obligation does she have? And I don't know that for certain. I suspect that the obligation that she's got is probably fairly minimal, because usually it is. But, like, I don't know for certain. And it could be that they say, like, this feels like crap to me. And the reason why it feels like crap is because if you thought you had a good case, you wouldn't mix it with, like, every grievance you've ever had. That's what you do when you've got a losing case and you want to make noise in front of the media.
The shotgun or the kitchen sink approach.
Yeah. It's
right?
if you're serving steak, you don't serve it next to shit, because it
Well,
doesn't
that's
make
an
the shit
analogy.
better. It just makes the steak shitty. So
Really? Okay. But yeah, no, I'm with
you
you. I'm
knew
with
who
you. Like
I am.
I know, but I also know what you're talking about, because one of the things that's interesting to me is that this is at the indictment stage. Good night, Leo. We're not gonna rile him up. One of the things that makes this interesting to me is the indictment phase, right? So indictments in appellate jurisprudence, by and large, the appellate courts don't like to disturb trial court findings. They just don't.
Mhm.
And appellate judges, especially intermediate appellate judges, which is where this would go, I believe, they very much, I'm going to say something that might be a hot take. There's a little bit of cowardice there. They don't like to stick their foot in the pot if they don't have to. Like, they find any reason to yeet something if they don't absolutely have to decide it.
Yeah.
That's what this started feeling like. The more that they kept arguing, the more I was going, they're not going to hear this. They don't want this. They're not going to go. No, I'm not going to go overturn the indictment and go back all the way because of all of this stuff.
Yeah,
Yeah.
I think it's a long shot. And I think they think it's a long shot, or else they'd have filed it differently. But I mean, it's not nothing. I think that they've got like a 30% shot, which is amazing
Yeah.
for like
Yeah.
for striking an indictment, right? Um,
What are you thinking? Like 3% being is no, like 2% is the
0 is the normal.
yeah,
Like, I would
it
say
just
it's
doesn't
like,
happen.
I would say it's normally like you start out at 0 on those. And the fact that they moved it up to where I'm thinking like 30% is a big achievement. But it's also like, don't count this out at this point. Um, it'll be interesting.
Yeah, I'm waiting to see the argument on it. I think Baldwin's lawyers, one, this shows you the caliber of Baldwin's lawyers. They're not going to give an inch. They are going to fight every
I mean,
single
I
thing
thought
they
this
can.
could have been written a lot better, but
They're going to fight every issue.
they're not gonna like bowls it up where they just kind of sit there and sleepwalk their way through some of it.
Wait. I'll give you the chance. I swear to you, I will give you the chance, because that's the next topic on the
Well,
bowlsing it up.
I've described Bowles as like Weekend at Bernie's lawyering.
Oh, that's
Come on.
I'm not.
Tell me it's unfair.
I'm not going to disagree. Like, there were so many times when I was going, "Why are you doing this or not doing anything? Why are you not objecting? Why are you
Why are
not
you
preserving
watching
the
your
record?
client screw herself in the
Why?"
yeah.
Yeah, you know what was funny is I did a client interview in a different case in front of authorities, where it was a very limited case where you kind of have to. It involves the investigation of certain incidents of family stuff. But
Yeah.
I was there with my client and I did 95% of the talking. And but we'll get to that. Trace Fagan asked an interesting question. Can you use grand jury testimony at trial? Nope. None of it.
Can they cross-examine on it?
Very limited exception. We saw this in not the Baldwin case, the Murdoch case. Very limited exceptions to this, where you are trying to impeach a witness who had previously appeared before the grand jury, which is another thing that Morrissey did that I thought was very smart. Haig, right? The firearms guru, the guy that was
She got kid to appear in one place and dad to appear in the other.
Yeah, that was a good move. That was
sneaky.
I was wondering if you caught that. I shouldn't have even wondered. I knew that you would have. So
that was
there
sneaky.
are cases.
That
was impressive. That was really impressive.
mm-hmm.
So grand juries, right? So the only time you can ever use grand jury testimony at trial is like what we saw in the Murdoch case, where the investigator for SLED testified in front of the grand jury about the shirt that had, in this investigator's mind, blood all over it, yada, yada. And that was what he said to the grand jury. Well, it ends up, after that indictment is returned, that the forensics come back and know that wasn't blood. So now you have the same investigator who's taking the stand at trial, who has made a previous statement under oath that you can then impeach them with, which is what they did. And the shirt became a big issue that we didn't hear a whole lot about in Murdoch because of that particular point. So you can use the testimony of the same person at the grand jury proceeding when they go to testify at trial. But what Ian and I are talking about with Morrissey was, there was an expert that presented at Hannah Gutierrez-Reed's trial, Mr. Haig, and I forget the father's first name and the son's. I think Matt was the son's first name.
Is it Lucian?
Matthew. Might have been Lucian, but the father was the one who testified at trial. He was, and for those wondering about credentials, this guy was, I loved him. He was phenomenal. The dude literally had all of the information, knew everything.
He was
about
the investigator who knew what he was, or the firearm guy who knew what he was talking about, as opposed to the one the defense brought, who was hilarious. And I'm going to have a video coming out on that soon, because they should have known he was going to be hilarious.
So
I went and did some digging. The guy is, the guy was born to be comedy.
The father, who is the expert, Haig, Father Haig, testifies at trial for Gutierrez, and you'll see him again at the Baldwin case. But at the indictment phase before the grand jury, the son testified. Both were present in the room, but they're not the same person testifying. They were both observing, but they were not the same person. So the son
also might have been to
get
the son some testimony experience.
It could have been, but it was very freaking smart, because now you know what you can't do. You can't use the son's testimony to impeach the father.
Yep.
Oh, it was. I read that and I was like, oh, that is so smart.
It's sneaky.
It was a really good move. Really good move.
I mean, if I'm defense on that, I'm pissed, but there's nothing I can do about it.
No, that's why I say it's a good move. Kale Burke's taking shit. It's what's for dinner. Oh, that's a terrible dinner. Stephanie 1208. My 3 cats follow me to the bathroom and ensure I'm safe. Or do they? JT, think Morrissey understands.
It's what they're just bad at it.
Yeah. JT says thinks Morrissey understands Spiro isn't Bulls. I don't know.
I don't. I think she just goes at the same pace no matter who she's up against.
Yeah.
Like, I don't think that there's any. I don't think she's adjusting her tactics based on anything like that. But yeah, I mean, they're going to go hard.
It's going to be very interesting to see. Cindy Collins, I just finished college today, officially an accountant. Congratulations. Have a cocktail, pour one, have some fun, enjoy the weekend.
I need to get a drink. There's a lot of celebrations, and
you're welcome to. You want to go do that?
I'm going to go get a drink.
Go get a cocktail. I'll pull you down. All right. While Ian's doing that, we'll catch up on some super chats. Congratulations, Cindy. That's an amazing achievement. Sandy, thank you for giving super chat, or thank you for giving memberships. You don't have to do that. You're a mod. For those of you guys watching, please thank the mods. The moderators are phenomenal. They keep the chat clean, keep the chat on topic, dialogue moving forward, and they put in a whole lot of work for not a lot of appreciation. I try very much to thank them every time I can, and they do so much that I feel like the gratitude I could give would never be enough. So please thank them. They're phenomenal. And why they give memberships, I will never understand, but they do. And no matter how many times I tell them not to, they still do. Robert McNamara, I personally want to thank you for helping me understand. Thank you, Robert McNamara. Kat, I wanted to pull this one up because it was a good one. Just curious if you guys can break down the new lawsuit against Apple. I don't understand the grounds for a suit. This is a great segue, because the answer to that question is, unfortunately, I have not read through it all the way. However, I have a very good friend who loves stuff like this, who handled discussions of, let me see if I can't, who handled discussions of these antitrust lawsuits when it came to litigation. Let me find a good freeze frame for him, because I'm not going to catch him in a bad one before I share the screen. Oh, sorry, Rick. I don't want to do that to you. I'm going to do this. I'm going to just pull the channel up, because the lawsuit's very interesting. And I do have opinions on what I've seen so far. Those opinions are largely an issue, but he has a whole video where he reads through the entire US versus Apple lawsuit. So please go check that out on his channel, Hogue Law, Rick Hogue. So please check that out on his channel, because he's did the breakdown on that, and I need to go finish watching that because I'm very curious about the lawsuit. From what I saw, the press release doesn't match the allegations, and it gives me a really icky feeling on the reasoning for filing it. I don't know. I just feel like there's not a whole lot of there, and it feels like a stunt. Like it feels like a whole, like, I want to, never mind. It just feels like it doesn't have a whole lot of meat to the argument, and I don't see the press release aligning to the allegations of the complaint, and the complaint itself seems a little bit meandering. So I'm very curious. I want to catch the rest of Rick's interpretation, but Rick Hogue, please go check out his channel for all of that. Maddie Retman, would you rather be a part of a jury or a grand jury? Grand jury all day, baby. Give me the unfiltered, unvarnished things I can't hear in court. Jury, fun, but I'll never get that chance. Maybe grand jury. I don't know. I'd be very curious to be on both. Elf Liggins, things I've heard a lot about: getting popcorn. Yeah, there's a lot to go around, man. Chris M96, why am I getting scared that if NC State keeps winning, there's going to be an NC State swoop? There probably will be, Kristen. I'm just saying, like, there probably will be. NC State keeps winning, and I mean, they won 5 in a row to win the ACC championship. Like, there's been one other team in the history of college basketball that's done that. So go Wolfpack. Keep on going. And DJ Burns, the big man for NC State, every time he touched the ball, the entire freaking stadium went nuts. It was awesome. So go DJ. That's my DJ. Babs Austin, good time Fridays. Wonderful. Thank you, Babs. Babs, I've spent 8 months with you guys opposed to watching The Man from U.N.C.L.E. Oh my gosh. The Man from U.N.C.L.E. as in The Man from U.N.C.L.E. the movie or the show? Because I will say the adaptation they did with the movie, I loved. Did you ever see the movie adaptation of The Man from U.N.C.L.E.?
Yeah, it was actually surprisingly good.
I loved it. Like Hugh Grant, Carville's in it. It was great. Freaking phenomenal. So highly recommend that movie. But you know what? That's what Saturday nights are for as well. So spent 8 months watching you guys opposed to watching The Man from U.N.C.L.E. on Friday nights in the 60s, opposed to watching The Man from U.N.C.L.E. as I did Friday nights in the 60s. Oh, that's probably the
show.
YouTube is doing this weird thing with super chats right now. And I know this because I was super chatting on Ian's channel on Monday when I couldn't jump on. There's like autofill weird stuff going on. YouTube knows about it. It's been reported, but they haven't fixed it yet. Like when you're on your phone trying to type a super chat in, it's going to start autofilling and like doubling up stuff. I'm sorry, I can't fix it. I'm not YouTube, but take your time. Thank you for sharing. Man from U.N.C.L.E., great movie. Also a good show. Just because motion for Rob to appear on the Janet Doc video, just in the corner eating popcorn. Oh, I could. What if I just sent you a clip of me just sitting there eating popcorn? You could put on repeat. I need that bumper, like, so you can pull it up, like just me eating popcorn, like as you like just read. That's pretty good. That's a good idea, just because I love that. Midnight Jury, thank you for the gifted membership. Stephanie1208, thank you for the gifted memberships. Much appreciated. Kenny Peterson, thanks. Robin Ian and the great mods. You rock. Thank you, Kenny. You rock. Molly Biddy, thank you for becoming a member. Much appreciated. Bravo Chick. Whoa, 5 months. Holy cow, time flies. It does. And I owe the members only chat in the shop. I very much owe that. The shop has finally gotten to a state of somewhat repair. So I haven't made a pen in a long time. I haven't made anything in a long time. And
someone sent me some leather scraps and basically said these should be durable enough to withstand a Zora attack. And so
challenge accepted. Oh, you mean for her collar? For her collar?
Yeah. So I'm gonna have to measure her neck, which of course she's gonna be just super thrilled about.
Yeah, very happy.
There's nothing a dog likes better than have you wrap something around their neck. It's like, Zora, I'm not trying to strangle you. I've got every reason to, but that's not what this is about.
She's so cute. Tell her to stop communicating with Leo, please.
Yeah, like she listens to me.
I know. Like Leo listens to me. Canonical Heat, like, subscribe, notification bell, push those for luck, and appreciate the fabulous mods. Thank you, Canonical Heat, for reminding me and for doing this every single stream. You guys, if you wouldn't mind hitting that little like button, really easy to do. Just hit the like button. I'd love to see this video get up in likes. And then if you enjoy the content, Ian and I going back and forth, please hit subscribe. I might have a Google Maps update at some point in time in the near future, which we can then rehash stuff, which is all good fun.
Rob, it's your fault if you crash into a wall. That's on you.
But thank you, Canonical Heat, for doing that. Aussie J, listening while painting the house, nice and sunny, beautiful. I love sunny days, and painting is cathartic and fun. Judy M, 4 months. Thanks, Rob, for interesting content. Thank you, Judy, for being a member for that long and for enjoying the content. Shell C, thank you for gifting the memberships. Canonical Heat, 2406, watching, 903 likes. Looks stern, wags finger. That was to the chat. So yeah, hit the like button, guys. Time Lords gifted 5 memberships. Thank you, Time. And there's another mod. My mods are gifting stop gifting memberships, mods. Your mods. Thank you. Like, but you don't have to do that.
Yeah, mine doesn't listen to me either.
Yeah. Tide. Yeah, she's an angel. Tide's an angel.
She's an angel, but she doesn't listen to me when I'm like,
no,
super chat.
She's
like
very stubborn. Very stubborn. I know. I think that's yep. Elizabeth Walker, wow, 18 months and of insight and fun. Love you guys. Thank you, Elizabeth, very much for being here. LJ Peach, we had a German Shepherd we had to get a calf collar for. Oh, damn. That's some thick hide. Like that's a collar. Like for a calf? Wow. Oh, that's stubborn dog.
The next version of the Zora collar will be built to be a little more durable than the last one.
Dystopian Justice. Ian, thank you for grabbing this one.
Ooh.
Or Ian or Sandy grabbed it.
That was Sandy.
Thank you, Sandy, for grabbing it. We put our dog down early this morning. She went into seizures last night. $1,000 vet bill, diabetes, organ failure, good old healer. Aussie Shepherd dog. Our eyes are so swollen. R.I.P. Cleo. Well, Cleo is bounding across that rainbow bridge and herding everybody into the communal place where they can all have fun and play and watching over everybody. Aussies are remarkable dogs. They really are. They're so smart, so sweet, and they're just big, fluffy lap dogs. So I'm sorry for your loss. No one can. Losing pets is something that's really hard. I'm sorry for that. So I hope you remember all the good memories and that you recognize that your pup is not in pain, no longer seizing, and is enjoying time across that rainbow bridge. Cheers to you, Cleo. On the same note, pets are pets. Elise, my cat Zora would jump into my pants while I peed. See, that's the thing. Animals, they make you cry, they make you laugh. That's It's all the above. Kantari checking in from Chile. Drinking energy drink because I'm pulling overtime yet again because being chronically ill is expensive AF. Chronic illness and chronic pain, two things that are remarkably stressful and difficult to deal with in a life. Ian deals with chronic pain all the time. And some of the times that Ian's on stream is because he can't sleep because of the pain.
It's true.
So I'm sorry that you're going through that. And I hope that we can bring a little laughter and levity to that, because that's the other part about streaming and why Ian streams at that time, because he likes to bring levity and talk about stuff that makes people not think about that. Tiffany Bernier just got out of the hospital again. So drinking your meds, drink your meds, drink your water, get some sleep. You can't do anything if you don't recover properly. Something I remind Ian of quite a bit. Tracy Fagan, well, Rob, get used to it. 3 kids and 2 dogs. I can't remember the last time I went to the bathroom alone. Yeah, it's just, yeah. We'll all be under the same roof at some point very soon. DSN, gifted memberships, thank you very much. Ian Paler, how much for the emotional distress counsel? A lot? I don't know. Is this for Leo? I can't compensate for the pee on the head. That's a weird thing to say. Canonical Heat, go Cougars. Washington State did win. They were phenomenal. Lindsay, missed both of your ties. You don't have to miss mine. It's right over there. It's there. It's there. I got it. We missed the ties too. We miss hanging out. Great time in Vegas. We need to do it like that. That needs to be like a semi-annual thing where we get together. I am halfway being talked into going to Crime Con at the end of May in Nashville.
Tempting.
It's tempting. I have to get around to see a lot of people.
I know. Well, if you're going, there'd be at least 2 people I'd want to see.
Yeah. We'll have to figure that out. Kansas Jayhawks. Interesting win last night. It was tough. Controversial call at the end. Tommy Jones, hello. Rob, Ian, mods, and chat. Awesome place. Thank you. Canonical Heat, thank you for the gifted memberships. Sardanism, Sam Brazen Fraud. Dawn, thank you for being a member for 5 months. Fiona, thank you for gifting 10 memberships. Iris, hi, Rob. Hi, Ian. Listening in from Germany. It's 1:45 a.m. Well, listen as long as you can, but don't forget that rest. 20th Century Fox, mwah. To Rob, Ian, and chat, happy to be here. Thank you for being here. Crazy Cat Queen, congrats on NC State making it to the second round. Yeah, baby. Baby Steps 22, gifted 5 memberships. Thank you. J. Michael RN, so excited to catch an FNF from home and not work. Hope everyone's doing well. F Cancer, the horse she rode in on and everything she brought with her. I'm glad you're home, J. Michael RN. I know you've been working a lot of those shifts. Just because, thank you for gifting memberships. Much appreciated. Liz Salerno, happy Friday, everyone. Happy Friday indeed. Sensationally Social with Beth. So much this week. Happy for FNF, best night of the week. It's a fun night. Baby Steps. I think I called this one out. Thank you for gifting memberships. Iris called that one out indeed. Aaron, 12 months. Can't imagine life without Rob and Ian. You know what? Neither can I. Brother from another mother.
I mean, it would be very difficult for you to imagine life without you. That would be a weird thing.
It would be weird. I like I said, brother from another mother. Time Lords, Rob, don't gift mods. We do what we want. Yes, you do. Yes, you do. Lane Google Maps mock trial for Ian's fundraiser. Oh, that's an idea. Oh man, that'd be fun. That would be a lot of fun. That would be like Morrissey. That would be a lot of fun. SF Rob, get used to people not listening to you. I try. Sarah Gruber, had cousin at NC State at the same time as Rob. Go Georgia Tech. Ooh, ouch. That hurts my soul. Pants, jump into your what when you peed? Well, jumped into your pants. Gen V, Ian, have you heard of or used a moon clip before? Just learned about today. Hubby showed me a short of it. I'm curious. What's a moon clip?
Moon clip is for reloading a revolver faster. I have some for my for one of my revolvers, but I don't actually know where they are. And so I wanted to buy some more of them. And I don't know where I can.
I thought those were just speed loaders.
Sort of.
What's the difference between a speed loader and a moon clip?
So a speed loader is a little like machine, right? It's like a little device that you push it in and then it puts the rounds in and then you pull it out and so forth. A moon clip actually just sits in the revolver. Like you throw it into the revolver and then you leave it in there.
Interesting.
So
I see it. So it's basically like this little piece of like very, very thin, like aluminum that holds. Interesting. So you just shove that in, and then when you cycle the revolver out, like when you not eject. Help me here. What am I saying? When you cycle the revolver, when you remove and try to reload, the clip just falls on the ground, and you just put the next one in.
Yep.
Interesting. Very curious. Julia 543. Go Marquette. Hope we face each other. I like basketball at this time of year because it's so fun. Aiden T, just big shout out to Ash. Ash, she's always watching. Shout out to Ash. Thank you for always watching and having fun with us as we ramble through topics to endless hours of the evening or morning, day, night, whenever you're watching. Mispronounced name. Thank you for becoming a member. I have always loved that channel name or that name. Great name. Chris M96 don't really do BB. But go Tigers basketball, but go Tigers had to do it. Well, Tigers are trying to leave the ACC, so interesting. Lady O'Grady, new swoop idea, both Leo and Cat on unicorns, LOL. That's an idea for sure. Okay, let's swoop, and then we'll talk Gutierrez-Reed, and you can rant. You excited for the ranting part?
I am.
So Hannah Gutierrez-Reed, who was convicted just recently in the Rust shooting, and her attorney filed a motion with the court seeking to have her released after that convictions. And it was an emergency motion for new trial and release. Here's the thing. This part here where it says and release. Yeah, this is properly styled a motion for new trial because no, I don't want to do that because the arguments are for a new trial. The and release part is like, I'd like a do-over of what happened at the end of trial. So, Ian, what happened at the end of trial? And rant.
So at the end of trial, Carrie Morrissey says, hey, Hannah's just been convicted, so I would like to have her held in custody because she's gone from having the presumption of innocence to not that anymore, right? Because you don't have the presumption of innocence after you've been convicted. And so, so at that point, she says, hey, I want Hannah brought into custody, which is a bit of a dick move I'm just going to say, because they don't really need to bring her in my view, because she's not like a threat. She's not, she's not going to go out and commit further, the circumstances were very specific. She was working as a film armorer. So there's not really any chance that she's going to start working as a film armorer again. In fact, I would say the odds of that are below zero. But they still asked for her to be held in custody, and Bowles looked completely unprepared for this. He was pulling up the rules for how to deal with this on his phone to make the arguments. And that was a thing. Like,
it shouldn't have been.
It shouldn't have been a thing. when you're awaiting a verdict, or like when I'm going in for a trial, I am prepared to make submissions on, on things like release pending sentencing or sentencing. And sometimes it's just, sometimes your submissions are going to be like, we want a pre-sentence report. We have some time for that purpose, but you can't just, you've got to actually be ready to go. You can't be figuring it out as you go.
The example that I kind of go to is there are statutes that I use in family law that I kind of have the statute pretty much memorized. Like, for example, when a court ruling on custody visitation, court's required to consider certain factors and articulate facts under each of the factors that they deem appropriate for consideration in supporting their ruling. First factor, age, physical, mental condition of the child, with due consideration of the developmental needs of the child, given their age and experience. Second factor, the age, physical, mental condition of the parties. Third factor, the parties' ability to adequately assess and meet the needs of the child, physical, mental, and emotional. Four, the ability of the parties to cooperate concerning the needs of those child. Like, you know them. You just know them. And you can, at the very least, spout out a paraphrased version of them from memory. Pre-trial detention and post-conviction detention, there's factors to consider. Those are factors that you're so used to reciting and arguing over and over and over again. But
it should be like a lot of this should be. There shouldn't be something he's got to look up. Like, I'm sorry, this is not like, if it's your first rodeo, oh my God. Yeah, I don't understand it at all. So, but that is what it is.
So what we have is this. Emergency motion for new trial and release. Hannah Gutierrez by and through counsel, Jason Bowles. Trial was held in this matter from February 21st, 2024 through March 6th of 2024. And on March 5th, the jury returned a split verdict, finding Ms. Gutierrez-Reed guilty of involuntary manslaughter and not guilty of tampering with the evidence. Mexico Supreme Court just issued its ruling in State of New Mexico versus Taylor. That opinion is attached. In Taylor, the court reversed child abuse convictions on jury instructions error. Specifically, the court criticized the use of and or in listing various acts the jury could find committed by the defendant. The court also noted that such drafting of the instructions could confuse the jury and lead to a non-unanimous verdict on any particular act. So, what are we talking about here? The thing we're talking about here is the jury is given instructions. The jury is given the elements that they have to find. The elements of the crime. If you find, and you've seen the jury instruction forms, we've talked about them before and reviewed them.
It's also attached as an exhibit.
Oh,
it's
is it?
The last exhibit. Yeah. If you go to the end, you can see the critical instruction.
There. For you to find the defendant guilty of involuntary manslaughter on count one, the state must prove to you, dear satisfaction beyond a reasonable doubt, each of the following elements of the crime. One, that Hannah Gutierrez loaded live ammunition into a firearm intended to contain only inert ammunition, and or Hannah Gutierrez failed to perform an adequate safety check of the ammunition she loaded into the firearm. So this is the thing that they're focused on, this and or right there.
Yeah.
And the problem that I see at first glance, well, let me go to the case and see if I can't find the relevant portion of that case pretty quickly.
Page 19.
See, you covered this already, which is why I wanted to kind of hash this, because I wanted to talk about this more, because I think this is not a garbage motion, but it's really close.
Oh, it's a garbage motion. If I had a student submit this, I would yell at them.
Wait, hang on. Okay, so these are the instructions that resulted. No, yeah. Uniform jury instructions will be changed to reflect that find guilty of reckless child abuse. Child jury must find the defendant acted with reckless disregard. So reckless disregard, you're talking intentionality. Now you're talking the mental state, not the physical acts that took place.
It's
reckless disregard.
It's
Okay.
not that. There's this gets very specific about the particular charge in Taylor. And Taylor, how do I put this? There's basically two scenarios. And Taylor, the problem in Taylor is that they say, do you find that the person was, reckless by engaging in, and they list a bunch of and/or behaviors, but the and/or behaviors includes things like taking the kids for a drive when they weren't authorized to do so, which in and of itself would be not sufficient to establish the actual offense, because the offense that they were charged with is that they left the kids in a car in the hot sun, and the one kid died and the other kid suffered a brain injury. So the Taylor scenario is one where because of how the thing was phrased, it actually, I think that
here it's this one.
Yeah,
it's this instruction.
Yeah.
So here's what the jury was instructed.
Yeah, defendants did not follow the proper rules and procedures mandated by CYFD in conducting the care of the victims, including failing to do head counts, driving the victims without CYFD permissions, failing to have a proper caregiver to child ratio when the victims were in defendant's care, and / or failing to remove the victims from a vehicle, which resulted in the victims being left unattended in that vehicle and exposed to unsafe temperatures for a time period of approximately 2 hours and 40 minutes. Now, the key thing is the victims being left unattended, but the way this is phrased makes it sound like they can be convicted purely based on, for example, driving the victims without CYFD permission.
Yep.
Only.
And so, the other thing about this one is that there's a part of this where this instruction is made, there's a part where I'm applying the mental state to each one of these things. Did not follow. So there's the voluntariness, there's the actual action of intent, including failing to do head counts, driving the victims without CYFD permission, failing to have proper care, give her the child's ratio when the victims were in the care, and or failing to remove from a vehicle, which resulted in them being left unattended. It's that last part. Like, honestly, if this should have been its own, that last one, the and or.
Like, that last bit is...
That's the case.
That's the case. But the problem is that the way it's phrased makes it sound like they can convict
based on
even if
any
the
of the
only
foregoing
thing they find is that they drove the kids without permission. And that's not the law, right? The law says that they've got to have more than that. So what the court in Taylor says, and that's, our case here, is that this is improper because you can convict based on facts that shouldn't be sufficient to get you to a conviction. But they differentiate it on another case, like with another case called Godoy. And I may be mispronouncing that. It might, Emily was pronouncing it as Goody, but I don't know which the correct pronunciation is. It's Godoy. And that one says that if you have multiple paths to a conviction, that's fine if the jury doesn't agree on the correct path, just so long as they all agree on conviction. Because what you can get often is a situation where like let's say you think somebody committed murder either by pulling the trigger or like of the gun, or by being part of like being a party to it by like being present when somebody else pulled the trigger. And so either of those is sufficient to convict you of murder, but the jury doesn't have to agree as to which one it is. So like 6 of the jurors can think that you pulled the trigger yourself, and 6 of the jurors can think that you were there when your buddy pulled the trigger, and that's still enough to convict. The problem that you run into, like, Bowles doesn't understand the Goody scenario and the distinction between that and Taylor. And so he thinks that they have overruled the Goody scenario, which is what Hannah's in.
Yeah, that's what Hannah's in. So, and like, well, this is the Godoy, and I think you're right. It's Godoy. So Emily's wrong in pronunciation. That's definitely Godoy.
We're just going to go with Godoy.
We're going to go with Godoy, reiterating that where alternative theories of guilt are put forth under a single charge, jury unanimity is required only as to the verdict, not to any particular theory of guilt. So if I am basically saying this person is guilty under this theory or this theory, and all you have to do is find one, but the conduct itself is guilty conduct and guilty action, guilty intent, that's alternative theories.
Yeah.
The previous case was you had to find some combination.
The Taylor case, the reason why is because one of the things included in the and or is a scenario of innocence. Because if the jury doesn't find that
it's not, doesn't lead to the death.
If they find that those women didn't actually leave the kids in the hot car, but does find that they, drove the kids improperly, without permission, that's not enough to convict them of the deaths of the kids. But the jury charge in Taylor makes it sound like it is. So that's why Taylor is a bad thing, but it doesn't apply at all to Hannah. And like Bowles comes in really hot in this filing. He says that this is he says that it's virtually certain or something along those lines to result in a new trial for Hannah. And I'm like, my dude, it is not.
Well, and even a simple reading of this, like just let's read the two instructions next to each other. So I want to do that. Like, let's read the two instructions just back to back. Okay. So in Taylor, the instruction is as follows. Defendants did not follow the proper rules and procedures mandated by CYFD in conducting the care of the victims, including failing to do head counts, driving the victims without CYFD permission, failing to have a proper caregiver to child ratio when the victims were in the defendant's care, and or failing to remove the victims from a vehicle, which resulted in the victims being left unattended in that vehicle and exposed to unsafe temperatures for a time period of approximately 2 hours and 40 minutes. Just reading that again, that and or that last one, that's I'm sorry, that's the case. You cannot convict unless you find that. Like, you have to
That's
find
the
that
thing, but the way it's phrased makes it sound like you can.
I know.
It's phrased in a way that makes it sound like you can convict on less than everything, and that's clearly wrong. So,
well, conversely, you have this. Hannah Gutierrez loaded live ammunition into a firearm intended for, let's do a different color, let's do green. Intended to contain only inert ammunition. Okay, so one action, and or she failed to perform adequate safety check of the ammunition she loaded in the firearm. Action number 2.
Either of those is sufficient to convict.
Correct. So you have alternative theories of wrongful conduct.
Yeah.
Then you have that she should have known the danger, which this knowledge applies to both of those theories.
And that's the second, like, it's a clearly distinct next step, right?
Yes. Because the knowledge would carry through, and if, like, here's how this works. let's say that we just remove this part, right? So only this first section of it applies. Hannah Gutierrez loaded live ammunition in the firearm intended to contain only inert ammunition. Disregard the next sentence. Hannah Gutierrez should have known that the danger involved with that action, that she acted with a willful disregard for the safety of others, that the act caused the death of Plaintiff Hutchins, and it happened in New Mexico. Okay, so that itself, if you find under boom, 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 all 5 of those, that is one theory that gets you to guilt. The other theory is that this course of conduct is what you find that we proved, that she failed to perform adequate safety check of the ammunition, that she knew the danger involved, that was a willful disregard of safety, that caused the death of Helena Hutchins, and that happened in New Mexico. That gets you to conviction. Those are 2 alternate theories, each of which stand independently and can both independently convict. So the jury can select alternative 1 or alternative 2. And both of those lead to conviction versus the Taylor case where if the jury picks like, I choose option A where they just didn't put safety belts on them, that doesn't get you to conviction. Right?
Yep.
So, okay. But Bowles takes this one for everything he can. This motion is really only 3 pages. Of course it is.
Oh,
2 pages.
you thought he was going to make a full pitch on this one?
Make
No.
an argument. Make an argument. 2 pages of argument. This is precisely the argument that Ms. Gutierrez-Reed made in jury instruction arguments for this court. Arguments are overruled and state made the same instructional error in this case using and or. See, this is what happens when you don't actually read the damn case law you're citing.
That's the thing, is he thinks that it means that any and or case is no good because he thinks it means that the jury has to be unanimous as to the theory of the case, which is not at all what the decision says. And I don't know that he actually read Taylor. Like, I get the feeling I don't think he did. And
not all the way through, he got the and or part. Like he read it really quickly, and then he was like, I want to throw a motion together, threw a 2-page motion together, 4 paragraphs of argument total.
It's your client's freedom on the line. You got to do more than just like, I'm sorry, I'm not doing a 2-page motion on this.
No, and you don't do this. Here's the other thing. You don't gaslight the court. This is gaslighting the court. In light of Taylor, the Court of Appeals or Supreme Court on writ would almost certainly have to overturn the results in this case. No.
And I got to tell you,
if you're going to say, I'm pissed when you make that comment.
Oh, yeah. After I've done reading Taylor, I'm calling you in to be like, so I would like to hear some explanation like of your theory of how this is, like, tell me again how this is guaranteeing you another trial. I would like to hear your explanation.
And that's the problem. So
I'm making you walk me through it.
Every one of these cases, a synopsis here, like at the very beginning, they always give this little synopsis of like the and or. And I bet he read the case synopsis, like the top end, and didn't actually go. And because the thing is, with these arguments,
that's not even my theory. You know what my theory is?
He just read the and or saw like the little headline about it that got released in the bar.
I think I think it was
it's the last one.
It's an email that gets like, because we get these emails, like I get emails that say, you know, where people are like, hey, this cool case came out criticizing and or in decisions. And I think that he just saw that and was like, cool, we're good. And he's not there. Like, you got to read the whole case. You can't just. So I think that's my theory. And maybe I'm not giving the guy enough credit, but
no, I'm with you, because you also have to make an argument that ties the arguments together. Like there is nothing other than the reference to and or. There's no like that appellate court opinion. This opinion, I will say, well reasoned, well articulated. It's convoluted. It's difficult. Like you have to read it to get there, but it makes sense when you read it.
Yeah.
Tie in what elements are you talking about where the and or makes sense? What elements are you talking about where they should not have been able to convict under that first scenario in the and or computation? It says this, but then oh my gosh, it didn't get worse. In the same paragraph is saying accordingly her requested court vacate her conviction or new trial. Like literally one sentence. That's all you spend. That is all you spend arguing this point.
I mean, there's two circumstances where you do this. Well, three. Option number one is you just don't give a shit about your client at all. Option number two is you think the case is so obvious that the court is going to be like, yes, we definitely need to be giving a new trial on this. And I think that's where Bowles thinks he is. Or option number three is you think that your own argument is such bullshit that you don't even, try. And yeah, first rule of legal research and writing, read the whole case, not just the headlines. I mean, the other possibility is maybe he did read the whole case, which would be even more embarrassing for Bowles.
There's a Supreme Court case, Arizona v. Gantt, where they walk through detention, basically seizing the person, and they walk through that argument, and the entire first page of that, if you were reading it, you were going, oh, they're going to find detention fine. It's not until you get to like the last paragraph of that first page where it's like, and this is why we're overturning it. And if you didn't read all the way to the punchline and you cited that case, well, you're in some trouble.
Yep.
So,
well, I mean, I mentioned on another stream, I said I had a circumstance where the prosecutor brought out a case midway through trial and, handed me a copy of it, and they quoted it. And like, I could tell you, it felt like I got punched because midway through my case, the prosecution has just brought out this, this case, and it is fatal to me. Like, the quotation they read was just like, oh shit, there goes my whole argument. Like, I am sunk. How did I miss this? Like, my client's going to jail, and it's because I missed this case. And, that's not incompetent, but it's still shitty, right? It's still not a place you want to be. And so I was just like, how did this happen? How did I miss this? But they've handed me a copy of the case, and I am reading it as fast as I can while they're telling me just how screwed I am. And I noticed that they have made a little bit of an oops. And that oops is that they're quoting the dissent.
oh no.
And for the
No,
people
they
who are
didn't.
not lawyers in the chat, the dissent is the losing side. It is not law. It is now sometimes dissents later become law because there's
Yep.
a number of circumstances where dissents have
We-
eventually been
which is
adopted by courts.
really funny. That Arizona v. Gantt case I was talking about.
Yeah.
That was Roberts writing the opinion, and they adopted the dissent from Scalia in a prior opinion. By the way, people who hate Scalia was a badass when it came to criminal procedure. Like, he was like largely, I loved his case law on criminal procedure. He was the most logical person I ever saw. But the entire that opinion basically said we now adopt the dissent. Like, so they went through the entire whole, this is jurisprudence, and they said the dissent was right back here. But your guy cited the dissent.
And she didn't do it on purpose. She just found a case that she thought was fantastic. And I was a bit of a dick about it, I will admit, in hindsight. Because I got to stand up and I said, my friend has found a case that I acknowledge the quoted sections are absolutely fatal to my case and are absolutely, they're 100% on point. And the Crown, the prosecutor, is looking at me like, what the hell is he doing? I'm like, so unfortunately, the quoted portions are from the dissent, and the ratio in this decision actually agrees with me. And I got to watch her go, oh, like there's that little expression of like dying inside. And it's like, sorry. And the thing is, it happens. And it sucks, but
it does. And it's not something you don't like. It's not one of those things where some lawyers like dunking on people.
I was a bit too much on the dunk on that one. I kind of
You know,
needed to be because my client was a bit upper a creek. I did end up winning that trial, but you still, like, in hindsight, you're like, yeah, I wouldn't have wanted to be the other lawyer. I don't want to be that person all the time, kind of thing. So,
well, and
I
then
had my reasons for the dunk, but I don't want to be that person generally, if that makes sense.
So Bowles then uses this opportunity to kind of throw in one sentence like, she's further requesting the court release her. You had the chance to make the argument. You just
That's the thing
didn't. You didn't.
I would be going hard in the paint here because he didn't the first time.
So do something more than a one sentence.
Well, that's the thing is I'd be going, this gives me at least a thin excuse to make the full argument I should have made at the time. And, this is where you go absolutely hard in the paint. And you're like, I would have at least a full page on just this point, right? She has no criminal history. She's never had a violation. She's not a danger. Like, let's have a whole paragraph on the whole, like, on no violations on pretrial release. Talk about the conditions she's on now. Talk about how they're onerous. And say she has been following. Say, like, you mention her age when you're saying she's got no criminal history, right? You always would mention some, like, I don't know, like, what is she, 20-something? So you're like,
let me see. Post-trial detention statute, New Mexico. I'll find it. I'm going to find it. I'm going to pull the factors up. But the reason why I make this, oh shit, I found it in 2 seconds. Hang on. Right to be released, blah, blah, blah. Okay. Post conviction. Let me do this.
Like, you make the case. You propose a list of conditions. You say, like, just the sheer fact that it's serious should not be sufficient to hold Hannah, because that's not the entirety of the test. There's got to be a consideration of the rest of the test. Like, is she actually going to be a danger to anybody is a critical issue. Is she going to flee? You can say, like, she's not fleeing because she's got no money. Like, tell the court that. She literally cannot flee. She's got no money. And, like, make the pitch. Pretend like you give a shit, dude.
Well, and his version of making the pitch is this next paragraph. The jury instruction issue is virtually certain. And this is the part where I think the judge is going to, I'd flame the attorney here. Like, you're getting roasted by me in a pleading. Jury instruction issue is virtually certain
for
to
that,
result
you're getting
in a
roasted
reversal
by me in person
of the trial conviction under the new Taylor opinion reasoning. No, I am filing a response that literally questions the ethics of the person who cited a case that does not support the position that they're offering to the court. Like, this is almost intentionally misleading the court. It would be a manifest injustice.
I would say it's misleading the court if Bowles was better at his job. That's the one thing, is that Bowles has a great defense to the intentionally misleading the court argument because he just bad at it. And I think that the court can't really say he's intentionally doing this. They could just say, well, he's a screw up. But do better, Bowles. Do better.
Yeah.
Oh my God, I am pissed.
And then he goes, it would be a manifest injustice to keep Ms. Gutierrez. And this is the part, like you can take more pages to write a motion. You're not limited to 3 or 2. It'd be a manifest injustice to keep Ms. Gutierrez-Reed incarcerated.
Sometimes you have a limit, but the limit's going to be
2.
like 10.
It's not 2. Like I have 5. I can do a lot in 5 pages.
Yeah. It might be like 10 pages, in which case, cool. But you take your 10 pages, you take your 5 pages, and you know what? You can also easily justify splitting this into 2 motions. One motion for like the new
hearing
trial.
Yep.
And 2, your motion for, my client should be released. There's no reason why those, like, if you're under a page count, I don't think the court's going to give you grief if you split that up. Like, this is not a situation where they'd be like, oh, well, bullshit. They'd be like, yeah, no, that's fair. That's two motions. Cool. You're good to go. Like, advocate for your client. Weekend at Bernie's lawyering.
It's not the best because this sentence here, this sentence should have been 5 pages of explanation. This is especially true given that Ms. Gutierrez-Reed has no criminal history, has never had a violation while on pretrial release. She's neither a flight risk nor a danger to the community.
Explain that to
that part. Yep.
Like, she's not a flight risk. Why? How do we know this? Justify it. Back it up. Like, oh my God, dude.
I know. Yep. You're as angry as I am. Like each one of these in a motion will get a separate section. As we saw in SBF, like SBF, when he filed that pre-sentencing, pleading, his recommendation, each section got like 3 pages. So that kind of this bothered me,
as it should.
Yeah, I didn't like it. That wasn't fun to read. I didn't like that at all. No,
I mean, I hope Hannah gets out and sees that, like, I can say I don't much care for Hannah. I think she's a bad person. I think she did bad things, and I think she did it because she's careless and because she liked the idea of being an armorer more than she liked the work of being an armorer. And she never actually, she didn't, that she was cavalier with other people's lives. She liked being around big names. She liked being around cool guns, but she didn't like having to worry about safety. So she didn't.
She liked being an armorer. She liked the title that came with it.
Yeah. She liked that was cool, but she didn't actually like doing the work. And I think that's a pretty harsh condemnation of her, but I also think it's fairly accurate.
And you know what? In 9 out of 10 jobs, that wouldn't result in a fatality.
That's the thing, is there's a ton of things she just should not have been in a safety facing job. And, it is what it is.
And by the way, Ian and I are not excusing Baldwin. Like, I think Baldwin, I 1000%
that's not an excuse
that
for Baldwin either.
And I'm not saying excuse for anybody. Like David Hall, I didn't like the fact that he got the deal he got. That sucks.
Baldwin was offered the same deal. Hannah was offered the same deal.
How is Seth Kenny? Every link in this chain, I hate.
Seth Kenny, they couldn't have convicted.
Yeah, I know. There's not enough. There wasn't enough to get beyond reasonable doubt.
There wasn't a. I mean, it was
You
probably
didn't.
that
You
Seth
didn't.
Kennedy didn't actually have any connection to it.
Yeah, you didn't have a connection. You didn't have. You saw the scene there, and you saw
I mean,
the
other
set.
than
You didn't have
recommending Hannah,
boom boom.
like,
Yeah.
and I mean, that's not good, but like, there's no way that you know. So yeah,
Baby Gator says my Hannah would have been better with my cousin Vinny. Might have been. This is
I
something I
mean,
wanted to
my
bring up.
cousin Vinny did excellent work.
Oh, he did. He probably isn't being paid enough. Paid though. My thing is, didn't he? Correct me if I'm wrong. Didn't he take this pro bono?
Yep.
Yeah. So you don't.
At least
get
that's
the,
what's been reported.
And to be honest, you don't actually get to use that excuse. Like I didn't get paid enough.
No.
I have to do the job.
And I can tell you, if I've taken on a file pro bono, it's because I give a shit. And I 100%, if I am taking on a file pro bono, I'm going hard in the paint on that file. Like, we are, like,
Can I make
we're not messing around. We're going all the way.
a funny observation? You've used hard in the paint a couple of times. Do you know what that references to?
Not at all.
Basketball. You have been.
I knew it was a sports ball. I just didn't know which one.
You have been using a basketball analogy this entire time. Hard in the paint. The paint is the paint that exists between the free throw line and the box right there. That hard in the paint means that when you're going to the rim, that's when people exert defense and they do it physically. That's the physicality aspect of it. So you've been using a reference to sports ball that you just didn't realize you were using.
Fair enough.
Boom. I love that this is March Madness and Ian just said hard in the paint like 10 times.
I mean,
so yeah.
This is
bad.
This is where you're going full bore, right? This is where you're just like, I am going to fight the hell out of this.
Don't change it now. Use hard in the paint still.
Oh, fine. But it's very like if I'm doing something for free, it's because I give a shit about it.
Yeah.
And I'm not half-assing it. In fact, I'm going, you know, we'll do another sports ball and note that I'm given 110%. Like, you just, because if you're doing it for free, it should be because you care about it, right?
Yeah, you should care.
And I don't got a lot of regard for people who just like, you can turn a client down if it comes down to it. Mm-hmm. You could say no.
Yeah.
That would be that'd be an option.
And this is why the hard in the paint analogy works actually really well here, because that's where, like right there, where you're right up there, you're about to get to the goal line and score, it's going to get physical. And you know that you're going to have to put yourself at risk. And you that's the whole going hard in the paint. You leave it all on the line because you're right there. And you're not going to win the game unless you do it. Yeah. So I was disappointed. Crazy Cat Queen, what about just having pride in your work? Yeah, that's a good comment, because this pleading is now out in public. And if he was doing this pro bono with the hope of getting additional clients, I don't think that pleading helped him very much. Isaac, to your last comment, the 4,999 out of 5,000 other jobs, if it did result in a fatality, there wouldn't be charges for the same level of negligence, but famous people and gun make people irrational. The
thing is, I think there would be charges for these same circumstances for a lot of different scenarios. Like, let's say you're working at a factory and your job, like your one job is to make sure that, my wife for a while worked doing a summer job at an aluminum smelter. And one of the rules there is
I was just about to do like a plant of some sort. Yeah. Yeah.
You can't bring your own aluminum cans into that facility. It is absolutely forbidden, right? It's just, and the reason why is that if that fuel, like if that can gets into the smelter line, instead of just like the thing people think is that it's going to turn into more aluminum and it'll be fine. What actually happens is it turns into explosion and things are the opposite of fine.
Especially if there's moisture. Like if there's like a droplet, like let's say you drink like a Coke can.
Yep.
And it's like, oh, it's empty, but there's any moisture on the inside of that. You expose that in a concealed can at extremely high temperatures surrounded by molten aluminum and you get boom.
Yep. And that's the thing, is that what would happen is people would drink their can and like toss it on the line. Well, let's say your job is specifically to make sure that no cans are in the line, and you instead just bring a can of pop and you throw it in the line, knowing that this is dangerous and all of that. They could absolutely charge you.
Or you're texting, like they have a video of you texting while that belt is running by.
You're a mechanic and somebody comes in and says, hey, my brakes aren't working. And you give them the car back and you say, brakes are good. And you haven't actually done a damn thing on the brakes. You never even checked them.
Or you did it, but you got a text message like while you're doing it and you looked away and forgot what you're doing. And you just kind of said, okay, it's good.
Okay. Yeah. You don't have to make this personal, Rob.
No, I didn't. What I'm saying is I'm going to the negligence part where you're doing some of it. You're doing some of the job, but you're not doing it to the standard of care you need to.
Yeah.
That was what I was trying to get to. Like,
the thing is they couldn't find a single witness who said that they saw her ever check a gun.
And I'm sorry. The other point here that I have to make is that guns are different.
Guns are
different.
In Canada, the term is ultra hazardous, and that applies a different standard, which is that basically, because you're dealing with something that is super dangerous, and that's guns, explosives, airline maintenance, maybe like these kinds of things,
high voltage electricity, like.
Yeah. And that also, at least in Canada, applies a different standard of negligence, in the sense that normally, like, let's say you are doing something that is ordinarily dangerous, like, you're shoveling snow on a rooftop, right? And it's ordinarily dangerous because somebody could like accidentally sweep some snow off and it could kill somebody who's like 30 feet down. But it's not like explosives. Well, if you get taught wrong, then that might be a defense. Like, I was poorly educated as to how to do this. Mm-hmm. That might actually be a defense in those circumstances.
It's not what Hannah did. And that's the other problem. She gave the interviews.
Not when you're dealing with guns or explosives, because if you are dealing with explosives, and you say, I didn't know how to deal with explosives, it's not my fault, then the response to that is, it's still your fault, because your responsibility, if you don't know how to deal with explosives, is to learn or not do it, right? And guns are sort of in the same kind of category of, if you don't know what you're doing,
you don't touch
it. Don't touch the thing, right?
And so in the US, we have the same thing. We just don't articulate it in statute because we apply the reasonable person standard, but the reasonable person is assessing the situation they have. And that standard moves based on what materials you're handling, right? If I'm handling a big ball of cotton, right, the standard is different versus me handling a firearm. Standard's higher. Like,
Yeah, and I mean, people get crushed by a roll of cotton and that kind of thing. You name it, somebody's died doing it. But
probably true. Yeah. But yeah, so Isaac, I appreciate the engagement, man. I really do. Like, and it's a good point that you make, because there is a part of this case where it is the famous people in gun. It is. But I think that this particular case is one where I have been particularly interested in it, because I think there's a whole lot of blame to go around, and I want to see that blame cast appropriately and see the industry adjust.
yeah.
So, Baby Gator, I'll stop Rando. Oh God, I caught that for the first time. I'm not a lawyer, and I think I could have argued her release before sentencing better than Bowles. It was frustrating. Lisa Guetta. So are both EDB and Runkle Leo's attorneys? Yes, because they both call him their client. They are both his attorneys. Let me tell you what happens when I talk about Leo. When I talk about Leo, here's what happens.
Leo needs a team.
A portion of you run to Emily and you tell Emily about all of my accusations of Leo's misdudes, and then another portion of you run to Ian, and then there's a vast large number of you that go to both of them. So I get instant reports back from both of Leo's attorneys with threats of cease and desist letters and stop disparaging my client, and then demands for additional treats. Like, Leo's
like OJ. He's got a team.
He has a team. And apparently the glove didn't fit, so I had to acquit. Exactly. Blossom Fairy, thank you for having this community. Love FNF. Thank you for being here. You guys are what make the community great. Midnight Dreary, my son was first-time juror this week. Wow. Second day of deliberations was discovered another juror had phoned a friend for it. Oh, shit.
Oh,
phoned a friend for advice, mistrial.
You do not get to phone a friend.
No, he found the process fascinating, but hating no conclusion. Yes, and your son is now an example of why we have these freaking rules. Oh God, that's terrible. Sat through.
Well, not the son being the example. The
friend, the other person. Like, they're in day 2 of deliberations. Oh my God, that must have been a long trial too.
And that must have been so frustrating, because at that point it might have resulted in the whole thing getting thrown.
That sucks.
Can you imagine how frustrating that is?
I can't even. Here for years, turned 60 a few weeks ago. Happy 60th. Seriously loving senior discounts. Question: do you think Bowles' lack of preparedness at the end was because he thought he would win? I think he had a wrong measure of the case. So when attorneys go into a case, something I learned really early on. Every time you assess a case, you develop a theme. You create the theme for the case, and you kind of create this narrative in your mind. Like, think of it like a story. Just the narrative of what is the big picture I want the audience to take away. Yeah. And you have to accurately pick that, right? Like overzealous state, right? Overzealous state, wrong guy. Or there's a bad guy in the shadows, or something to that effect. You pick a theme and you stick with it. Bowles' theme was just the wrong theme from the beginning. It was other people had contribution to the fault. Problem is that Bowles' theme, even from his opening statement, admitted guilt for his client.
I mean, I think Bowles was surprised by the verdict. And you know why I say that? Because Bowles walks in and, like, with Hannah, and Hannah's got her jewelry on.
Oh, yeah.
And I tell you...
Was it 5 hours? No.
I tell my clients to never, like, have their jewelry, etc. Like, I talk about this with my clients before they come in, because...
Here, one sec.
You gotta assume that even though you think you've got the absolute winner of a case, right? Like, you are 100% gonna be in the clear. You've got to consider the possibility that maybe the jury or the judge doesn't go that direction. And, like, your client shouldn't be surprised by this. Your client should be prepared. And yeah, I just, yeah, it, God, it was a frustrating case. It's just, what can you do though? Like, I think Hannah should have been convicted. I just think she should have been convicted with better counsel. And I don't know if she would have.
I think she would have, but I think she would have had a better shot.
Yeah, I mean, it's tough to say, right? Because
you can't replay. So it sucks when you have a case like that where, like,
Bowles
Bowles
just virtually guaranteed to get a replay.
He missed the whole shot. Like he just did not see. I go to his opening statement because I think it's really important. His opening statement, for anyone who knows like the black letter law on this stuff, his
It's
opening
basically a
statement,
confession.
it admitted guilt.
Yeah. And
he literally said
people
she
got
didn't do
mad
what
at
she
me
had
when
to
I said
do.
that. I was like, this is not a good open. This is a confession.
He said she didn't do what she had to do, but there were other people that were also part of this.
Yeah.
It's not that bothered the hell out of me.
And one thing people said, well, what if she'd walked, it might have happened anyway. I'm like, sure, it might have, but in that case, she's in the clear. And if she'd walked, she's not the one on trial. She's like, if she'd walked and they'd taken those guns and, somebody had died anyway, she's not the one on trial. She's the prosecution's star witness.
Yeah.
Right. She's absolutely in the clear.
Kind of like the witnesses that testified against her because.
Yep.
Let me pull away from this real quick because I want to hit the last one here. Baby Gator, Bowles really thought they would blame production. They are liable too, in my opinion, but she had the. I don't like the word ultimate. I don't like the word ultimate because I think that there were so many failures here that I'm not going to attribute the ultimate blame to any particular person. I'm going to say each one of them played a very significant role in what transpired. And under our jurisprudence, that's enough to get you convicted.
Also, just a general life lesson about, getting along at work. The person you're calling the C word today might be the person testifying at your trial next week. So be nice to people.
Well, the C word was something. I didn't see you saying that.
Well, that was a moment. Like,
well, and it's funny that people made this comment, or John comment. Thank you, because I actually had this pulled up as a little bit of a palate cleanser. Kind of, yeah. So swoop. The YSL case, the Young Thug trial in Georgia, the trial that will never end. I was on Twitter and Kathy Russin posted on Twitter yesterday.
Yeah, I have not been following that trial, but I was kind of stunned to hear that it was still a thing.
I haven't been following it. I know just the very basics of it, like that they're using a lot of the rap music and trying to tie the people together based on the rap music and the lyrics. And honestly,
and I hate that.
It's really dumb. And it's also an example of why I think Georgia's RICO statute is unconstitutionally vague. I think it's a really big problem. I hate it because it leads to this kind of stuff where you're prosecuting these massive cases. RICO cases are really complex and they take months to try, even the most basic RICO case, because here's the thing. Every single criminal defendant has a lawyer that's present during every single witness testifying. All of those lawyers get a shot. Every lawyer has a chance.
And not like the fun kind of shot.
No, like a witness testifies and every lawyer gets a chance to contest the witness, to cross-examine the witness. It is a freaking mess. For those of you who watched the Fonnie Willis thing, like that was a hearing that was it like 10 lawyers in the room. It took 3 days to do on one issue.
But it was
Imagine
hilarious.
doing a full complex RICO case on organized crime and murder based on rap lyrics. What the fuck? So Kathy Russin posts this.
I honestly think music lyrics should be inadmissible unless they're incredibly specific.
I agree. If there were full court days, 5 days a week, even 4 days a week, this trial would not take as long. By the way, he's given the jury the entire week of April 1st off for spring break. Attorneys are going to argue motions April 1st and 2nd tentatively. So there's been reports that people are saying this trial is going to go till 2027, I think.
Jesus.
Talk about a lawyer's worst nightmare. So I kind of I joked back. This is the trial that never ends. Yes, it goes on and on, my friends. The lawyers keep on fighting each and every point they can. The witnesses are high and sleeping. They're sleeping just because this is the trial that never ends.
You realize that now the entire chat's going to blame you when they can't sleep later.
That's
because
fine.
They've got that crap stuck in their head.
That's fine, because this is the trial that never ends. And when I made the comment about the witnesses that are sleeping,
Rob,
what?
That is not fine.
Well, it's not fine. It's fine. There was a witness that literally said he was too high to testify. Hang on. Here we go.
To the side of the line.
How you had play something? I don't remember though.
And did you hear you explain that the case involving Mr. Dotson was totally dismissed?
Roll call, sir.
And for you, the case involving the armed robbery or attempted armed robbery or the aggravated assault on Mr. Dotson was dismissed. You pled guilty under Alford to aggravated assault on the 3 police officers.
Okay. I'm not really one to disparage anything. That man is seeing sounds. Like he is smelling colors and he is tasting like rainbow. Like look.
I had a witness in a trial at one point who had to be taken for medical attention.
For what reason?
He was ODing.
Okay.
Like, yeah. I can tell you the prosecutor was pissed.
Yeah. Let's see if the sound boost works. Hang on.
And fleeing and attempting to elude. True?
I don't remember.
And then I asked you, was Jeffrey Williams, before known as Young Thug, involved in any way, directly or indirectly, with the events involving Mr. Dotson on September 11, 2013? And you said he was not involved in any way.
Excuse me. You expect this man who's appearing on the stand right now with the answers he just gave you in his appearance. You were asking him a question about September 11th of 2013. 2013. You could give me as much caffeine in the world and and I could be like full alert attention, and you ask me about 2013 and I'm going to struggle. You think he's going to have that fucking answer?
You could give him enough caffeine to like literally make the guy into Lazarus, and he's still not going to give you the answer you want.
You hear that?
I don't recall, sir.
And
the question or
you explained, you just heard that you explained that they, we qualified that, you qualified it as the detectives and police. And I asked you the authorities, the police, the prosecutors, I just made it broad, that they forced Jeffrey Williams into it. Did you hear you say that?
Man, can I
Nope.
get a water or something?
There.
I'm so high right now, y'all. I'm about to go to sleep on y'all now.
How was that? Hang on. He says this in open court. This is an open court.
Jeffrey Williams into it. Did you hear you say that?
Man, can I get a water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all now.
Can I get a sip of water or something? I'm so high right now. I'm about to go sleep on y'all right now. Yeah. And this is why people wonder why lawyers do that dumb thing at the beginning of every witness where we said, what's your name? Where you from? And then we ask like, hey, deposition answers, by the way. When was the last time you had an alcoholic beverage? Are you under any prescription medication that would inhibit your ability to testify truthfully today? Are you under the influence of any drugs right now that might inhibit your ability to testify truthfully or recall events? That's why we ask those questions, because when that happens, you gotta say, Judge, I need a minute. Hi, I need to recall this person later when they're not this.
I ain't gonna tell you no lie.
I recall a trial I had where I literally asked the witness, because, he basically said that he gave a story to the police that made no sense because he was drunk. And I said, well, you're not drunk now. And he said, no, I'm high. And I was like, you're what? And he's like, oh, I'm high right now. And I was like, oh, are we talking weed? And he's like, weed, shrooms, meth, and what else you got? And I was like,
Keep the bottle up.
okay.
Mr.
It really helped that he was the prosecution's witness.
Stopped again.
Oh yeah. And I do not know that was he on the stand like for multiple days? This is like, oh my God, how high do you have to be to in open court admit that you're high? Well, when you see, if you have watched any of this trial, you will recognize this trial feels like a circus. Like it just feels like a circus.
Remind me. 349.97. You're on play further right from there. All right.
It's the judge's circus. These are his monkeys.
Speaking, and at some point around the 11-minute mark, you said they gave us a story to tell. Remember hearing that? And can you tell us what that meant?
That it was really telling us to like, hey, put Doug in on this right here. You know what I mean? If you don't put him on that, you could be facing a lot of time and all type of shit like that. You know what I mean?
And who is they again? I know.
To this point,
Okay. And the other prosecutors and police.
it was just really just him. And I was like, it was just really him I had made death with.
Okay.
And there was a few more officers that were just around, you know what I'm saying? He was in the hospital.
You're in the what?
I was in the hospital, you know what I mean? When shit happened. So it was like they pushed in, and I was at home. I don't know what's going on. So, yeah.
This guy does
Wait,
not want to be here. right
watch
now.
watch his head, because he's
As far as accident.
And that stopped it.
he wants a nap like so bad.
97. Did you hear me ask you about the jail recording that's now marked as Mr. Williams number 205 around the 11-minute mark? Me playing it for you earlier in Mr. Investigator Martin's car, and then ask you about it. About they gave us a story to tell. Did you hear that?
I don't remember.
And your response was that you were going to be in a lot of trouble, but the police wanted Jeffrey Williams in it And that conversation occurred on September 11th.
He's just like, dude, leave me
2013
alone.
At the hospital.
Trial. This trial. I don't understand. I am so confused.
You must not do
Why?
criminal law.
Well, the thing is, you see the criminal law stuff and you do, but a RICO case like this, where you have to pull in this many witnesses with this much evidence and try to prove this interconnected web, like,
Oh, but it's Georgia. They just need to prove that they're people who exist, and that's enough to be RICO. Are you made of matter? Okay, then that's RICO.
the guy
'Cause it's
literally said,
Georgia.
the lawyer goes, did you just listen to your answer? Like, do you recall giving me that answer? Did you just listen to that? And he goes, I don't recall. You don't recall listening to that like 5 seconds ago? Here's a good question. Why isn't the judge stopping the question? Because the witness said he was high. Because that's not the judge's job. That's the lawyer's job to basically say, I would like to stop the questioning. Or, because here's the thing, just because someone's high or drunk doesn't mean what they're testifying to is wrong, right? The jury can assess credibility based on the condition of the person presented in front of them. But if I'm the lawyer, if I'm the prosecutor, the last thing I want is to have this guy testify visibly high when I need his testimony or an effective impeachment of his testimony to prove my case.
Sometimes you just got to go with what you got.
And apparently this was, opposite amnesia says, solid 8 days. So was he on the stand for 8 days? If he was on the stand for 8 days, then maybe I understand getting high on the 8th day. Like, I get the 7th day God rested. Maybe the 8th day the witness got high. I don't know. What the heck? This witness. All the weed. Just give me the water. I'm high. I'm high as F right now. I don't know where I am. Sure. That's how that trial's going. And for those of you asking me, like, if I want to catch up and try to recap that trial, no. That's a whole lot of cluster of Fs that I don't want to try and unwind. So, Adam Mueller, I was an alternate juror once. Very frustrating, since I would have pushed to greatly limit the defendant's liability if I helped deliberate. Interesting. Alternates are sometimes game changers. The system is very interesting in that regard. But thanks for sharing. Marmar, watch Find Me Guilty. That was a long trial. What's that? Find Me Guilty. Find Me Guilty. Comedy drama. True story of the longest mafia trial. Oh, okay. This is when they tried to take down the old mafia bosses with the RICO statutes. Yeah, these trials were like years. RICO is so freaking hard. Will the real Ray E please stand up? Speaking of getting high, whatever happened to the lemon cheesecake?
That case is going to be ongoing for years.
Oh, yeah. I forgot. No, it was lemon pound cake.
Yeah.
Not lemon cheesecake, lemon pound cake. That was freaking great. Who was that? That was Afroman.
Yep.
Where he filmed and made a song based on the cops breaking in. It was great.
And Grass Folk says, how did they sit a jury for months? Let me tell you about complicated fraud trials. Because some of those get to be absolutely shitty. So when I started, there was a room, and the room was full of bankers' boxes full of paper. Full of them. Just packed solid. And I was like, what's this room? Is this storage? And they're like, oh no, that's an ongoing case. Because financial fraud trials can sometimes involve like money being moved around and huge amounts of accounting paperwork to figure out where that money went and when and how. So, imagine you're a juror on this, and it's going to take literally months, and it's going to involve going over all of these papers with like a forensic accountant trying to explain to you the trick that was used to make the money disappear. And you're just like, and the jurors just want to die. That's really where they are. They're just like, oh my God, I want to die. So, think twice before you think, I really would love to be on a jury one day, because you might be on a murder trial or you might be on a financial fraud. And yeah.
Well, and this judge has been using some pretty harsh means of keeping jurors there. Like I said, I don't know enough about this trial. It's pretty freaking wild. So is what it is. It's going to be interesting to watch. I'm not going to be able to watch it for 93 months or however long it's going to take. Maryland's running, ready to watch Iowa State second round. March Madness is madness indeed. Holly, last day teaching elementary students 411 starting high school. Cheers to you on the new position. Hopefully you enjoy it. Those high school kids. I don't know what's worse, elementary or high school. They're probably equally bad.
Different problems.
Different problems. Fair to tell.
Like elementary school kids can be real annoying, but they also rarely bring a handgun to school.
Right. I'm gonna hold.
Not never.
I don't know,
but rarely.
Not never. I don't know. Yellow Pill NP. I'm late. Did you see any of the fireworks between the judge and the defense? No, I have not. Because I mean, quite frankly, from what bits I've seen from this trial, I want to stay as far away from it as I possibly can, because I'm not seeing a whole lot of adults in the room. That's just me, my critique, my personal opinion. Anytime I seem to check in on the trial or see what's going on, it just seems like not a lot of adulting, which is frustrating to watch. So I would like more adults in courtrooms.
But
anyways,
get that.
I know. Sam Bankman-Fried, ready?
No.
Holler.
But we're going to do it anyway.
Going. That was so perfect. So perfect. Sam Bankman-Fried. Sam, Sam, what did we say earlier? Sam,
it's gone. The moment has passed.
It's past me. I'm going to stick with my favorite Sam Bankman, not so Fried. Sam Bankman, not so Fried. So we had last week discussed the sentencing memorandum by Mr. Bankman-Fried, where he said, no, don't worry. I am just this sweet, innocent, cute little person that's never going to do anything wrong. And I had no knowledge of anything. My gosh, I'm a victim in all of this. Terrible injustice. And by the way, please don't seize my shit, because no one was injured.
I have such tremendous remorse, but I also would like to keep the money, please.
Yeah, I am remorseful for my conduct. I want and oh, by the way, the customers are going to be made whole, because the bankruptcy says that they can be. Oh, baby. So the government got to weigh in on that. Give me 1 second. The government got to weigh in, and the government had opinions on that. The government basically said, no, we rather firmly disagree with.
I think their opinions can be summarized as F and U.
I mean, they could have been, but they didn't. They did it much more eloquently in a very lovely sentencing memorandum that has a more lovely table of contents, because the table of contents hits all of the things that we were thinking about when we read the memo from Mr. Sam Bankman-Fried. Okay. Preliminary statement, background. The offense conduct proven at trial, fraud on FTX. FTX customers, fraud on FTX investors, fraud on Alameda lenders. So we have three elements of fraud on everybody. The defendant's scheme to make unlawful political contributions, the scheme to bribe Chinese government officials, the banking misconduct. The defendant tried to deflect blame and evade responsibility after FTX declared bankruptcy. He obstructed justice, the use of signal to auto-delete, the witness tampering, and the perjury. Well, that's a hell of a, like, that's a lot of things in 31 pages. It's fantastic. Application of the guidelines, the calculation of the sentencing guidelines. The defense challenges the guidelines, calculations lack merit. I love the phrase lack merit. I feel like it's so much stronger than like aren't great. That was a dumb statement. I take that back. Like there were better words to use. The evidence at trial proved that the loss amount is at least $10 billion. Fair. Applicable law, trial evidence regarding loss amount. The defendant's assertion that the loss amount for FTX customers is zero is meritless. Yeah, I'm with you, government. Wow, words I never thought I would say out loud.
Mm-hmm.
It kind of hurts I don't know if I like it.
I do not like it.
Felt weird coming out. It felt weird saying it. But I largely agree with this. I think the government kind of didn't go all in. They could have. Even setting aside FTX customers, the loss amount to FTX investors is greater than $1.7 billion. I agree with the government. In the alternative, the intended loss is even greater than $10 billion. The intended loss part, I want to cover that part. That one
would have stolen more money if you'd been able to.
Kind of. Oh, Emily's here. She's here for the chaos. Here for the chaos. Mama, what? Mama's here. Emily is going to try and reign in the chaos / cause more.
I was going to say rein in. That's not how any of us operate.
Charge would be called gassing. Oh God. Okay, spicy Emily tonight. All right. So Emily, we're gonna call her the chat mascot right now. Because oh God, you guys summon EDB. I talk about SBF, you summon EDB. The number of victims enhancement is applicable. The bankruptcy fraud enhancement is applicable. The relocating outside the United States or sophisticated means enhancement applies. The enhancement for deriving more than $1 million in gross receipts from a financial institution is applicable. Enhancement for abuse of trust is applicable. All of the enhancements are applicable. All of them. Every one of them. A sentence of 40 to 50 years imprisonment is necessary. Well,
and desirable.
Wait, hang on. I'm getting a private note here. Gassing under the California Penal Code for assault with bodily fluids. Oh God.
Did you not know what that was?
I did not know what that was. Like, look, the family lawyer part of me doesn't inflict family law stuff that I know on you guys.
But
I didn't know that. I didn't need to.
Yeah, there's various ways they do it, and some of them are worse than others.
Did not need to know that. So
I also just sometimes called shit bombing. So
so you were listening, you little God, you purple-haired pain in my ass. It was an accident. I washed his head. He interrupted me in the bathroom.
Mm-hmm.
Oh, I hate all of you. No, I don't. You're all amazing. It's actually really funny.
So sometimes you'll get people in custody and they may have a grievance with somebody. And they'll take a bag or something along those lines because they have access to those from like they get ramen, it comes in a plastic container or whatever. And they'll mix number 1 and number 2, and it'll sort of turn into a horrible liquid.
No. Ew. Really?
And if they're really feeling salty, they can leave it to like ferment. And then they can throw it at people, and those people are often prison guards. But the other thing they'll sometimes do is if they've got somebody who has annoyed them, they might go and like, sort of compress the bag such that it sprays out.
We can stop now.
And so you'll get somebody who's in solitary who like where there's just like that little feeding hatch, and somebody will gain access to the outside of their cells, and they'll just like suddenly blast. And it just makes
so anyways, I was in solitary and I started blasting.
Or somebody was in solitary and somebody else blasts at them.
Ugh.
Can you imagine you're already stuck in custody and then just suddenly
No, I can't. I don't want to. All of that.
I mean, you probably could if you thought really hard about it.
Oh, it is my 2 favorite, more neurodivergent people than me. Like I am ADHD. I am ADHD like to a very, very large degree. Ian is a level I have never experienced in another human being. Emily is close to it, but not. Emily,
I may be the high scorer.
Well, Emily does one-person streams for several reasons. One, she loves her community, protects it, does a great job with all the content she does. I love all of her streams. She does a phenomenal job. 2, her level of distraction and chaos is equal to Ian Runkle. And if she were to have guests on all the time, she would never have a stream shorter than 2 hours, ever. It would not be possible. Every stream that she would have would go 6 hours because they would just go. It is just...
You say that like more Emily is somehow a bad thing.
No, it's phenomenal. I love it because the thing is we go down paths and avenues of discussion that become remarkably interesting, fascinating. And quite honestly, a lot of people that I haven't known in my real life have come to me and said that their kids with ADHD, that a lot of our discussions about this has been remarkably helpful to their children or how they deal with children, or teachers have come to me and said that it's been helpful for them in how they deal with kids in their classroom. So no, I have no negative thoughts about that at all. I just love my 2 favorite little chaos gremlins, agents, friends, angels, whatever you want to call them.
One of my favorite messages was somebody reached out to me and said basically that they have an ADHD kid who was kind of feeling a little lost in the world and a little... and they basically said that watching you and Emily and me basically helped their kid understand that like there's a place for them. They can do things that aren't just like being in trouble and so forth. And that it helped them sort of get interested in like, trying to put in the effort to it, in school and so forth and doing better, because it's like, hey, this is a thing I could actually do, right? There's people with ADHD who can function and who, so I was like,
a trial lawyer, like you can be a trial lawyer, you can be a litigator, you can do a lot of really cool things. You can be a lot.
So that made me kind of tear up a little bit. And, yeah.
I love those remarks. They're my favorite. And honestly, it's like one of the reasons I love Emily had one of the lessons that she taught me when I was first starting out almost 2 years ago. 2 years ago? Holy crap, 2 years ago. Was
Time
community.
flies.
It's community and it's people and it's putting those people around you that you trust to put in front of that community, and then also just protecting them and keeping them like, I don't mean protecting them like in a bad way where I'm like shielding them from the outside world. No, I'm letting them comprehend the outside world through a different lens. So I'm giving them a way of understanding the outside world that doesn't feel in their face and invasive. And I love that. And I love the chats about ADHD. And people are saying, DSN right here, how did we go so far off the main charge? Well, because
That's how we roll.
How we roll. And some of my favorite things that ever occur on live streams is because of that. And honestly, some of the most impactful things you guys ever send me, like comment wise or email wise, is because of those live streams that go completely sideways when we get into topics that I had no intention of discussing. So I love it. Emily goes, I've never had a stream shorter than 2 hours with guests 5. Yeah, I know. It's not possible. Because one thing about Ian's ADHD that it has taught me is that when I am confronted with someone with ADHD, it actually triggers something in me that, like, I don't know, my executive function becomes heightened. Like, because I recognize the people that are around me that have less.
Also, sometimes it's fun to be able to just be, because a lot of the time when you got ADHD, you're spending a lot of your time
focusing,
adjusting your manner of existence to other people. And sometimes it's really nice to be able to just be like, all right, here's how my brain is. That's going to be just how we roll for the next little bit. And it's really relaxing in a way that's hard to explain.
Yep. Honestly,
So,
I attribute you, Emily, and a lot of friends that I have to my ability to now manage associates. Like managing a live stream with all of these fun folks. Purple-haired Vixen, Alita, Rick, Ian, Kurt, whoever is on the stream at the moment, Pro Topics, David. Managing those, like people say herding cats. It is harder. It is a lot harder. It is so much more difficult because I can't spray them in the face with water. Like I can't actually physically like squirt a water bottle in their face.
We appreciate it if you don't do that.
Yeah, duh. But redirecting attention, but keeping people on track, but also allowing for those side tangents where they become constructive. Has really been a very cool lesson that I think I've learned, and I've tried to become better at it, where I manage the offshoots and the tangents to keep them in a productive avenue. It's very difficult, but it's also one of those things where recognizing my own ADHD and managing those around me that have it or any neurodivergency and trying to not impede their thought process, but guide it with that recognition in mind has been very rewarding for me personally. I have very much enjoyed that and seeing that I have the ability to do that. I've loved it. It's been an absolute pleasure. So every experience I get, even when the chaos agent Emily joins in the chat, the comments about ADHD comments warm my heart. I love being able to help people relate to themselves and those in their life, even when those people end up in chat and derail discussion, but in a fun way. Chaos gremlins. Yeah, that's
Chat's not supposed to have guardrails.
All the chaos gremlins. You guys don't realize how much fun it is when, well, I hope you do. And I hope that's why you're here, actually. I hope that's why you're watching. I hope you realize how much fun it is and how helpful it can be. to allow chats to get side railed and sides. We had a lot of people earlier in the chat voluntarily express their desire to leave. Oh my God, I'm out of here. See you later. Can't do this anymore. Peace out. That's fine. Does it hurt to see? Doesn't bug me that much. Do I want people to feel welcome here? No matter what? Absolutely. But there's a certain audience of people that really kind of need to hear this stuff where it's okay. I really like that section of the audience. I love that section of the audience. I love all you guys, but I love the people that are here that need to hear it, even though they don't know it yet. Oh, Kimmy Locker. No, people are saying bye now. Don't say bye. No, you don't have to go. No, you're welcome. Everyone's welcome. So that was my little side thought process there. Anyways, back to this cool thing, right where we left off. Back to Mr. Sam Bankman-Fried. The sentence of 40 to 50 years in prison is necessary. The nature, circumstances, and seriousness of the offense warrant a very significant sentence. I agree with the government. A sentence of 40 to 50 years is necessary to protect the public and for specific deterrence. Given the fact that he did not acknowledge anything wrong and wanted to go back to making money to pay these people back, I agree with the government. A very significant sentence is necessary for general deterrence.
Also, somebody needs to clip Rob for his statement of I agree with the government.
Don't do it. Don't do it. Don't do it. Please don't do it. Please don't do it.
Of all the things Rob doesn't want clipped, that's
top
of the
that
line.
one. Not the whole I agree with the government. Very rarely. On anything. Yeah. Anyways, defendant's history and characteristics do not warrant significant variance. A sentence of 40 to 50 years is necessary to avoid sentencing disparities. Okay, then they go into forfeiture. Sure, the court should order victim compensation through remission as an alternative to restitution. So, where do we want to start? Because I think I want to start with, where did I say before? It's not the fraudery. That's boring. Contributions, that's boring. We know that. We know that. We know that. Banking, we know that. Deflect blame. Let's start there. The defendant tried to deflect blame and evade responsibility after FTX declared bankruptcy. The defendant's fraud didn't end with FTX declaring bankruptcy. Rather, over the next month or even after he had been arrested, the defendant disclaimed responsibility, blamed others, and tried to perpetuate his fraud further. For instance, Bankman-Fried told the Wall Street Journal, all these interviews, man, remember when we had do you remember that lovely stream when we were talking about all of the interviews that he was giving voluntarily to all these outlets about how it wasn't his fault and we could make the customers whole and this wasn't a big problem. Remember those?
And we were going oh my God, he thinks he's doing well, doesn't he?
Yeah, we made all of those comments and it was either these going to be played at trial, or if they weren't played at trial, you know where they would end up? They would end up right here in a sentencing memo. For instance, Bankman-Fried told the Wall Street Journal on December 6th of 2022, just 1 month after the collapse, that the collapse was a result of the margin position on FTX that, quote, got hit a few times and then got hit massively. He gave smaller explanation to Forbes on December 13th, just 7 days later, and the New York Times Dealbook event, which is cited in the defendant's submission. Parenthetical. The evidence at trial proved, however, the defense fraud was unrelated to Alameda's margin trading, end parenthetical. In an interview on Good Morning America, God, I love these interviews. Bankman-Fried blamed the deficit in customer funds on FTX's borrow lending facility, GX923B. That's a weird name for something that you have in your entity. Sure, why not? Despite an earlier conversation with FTX's general counsel, COUNSEL, after FTX's collapse, that this was not an adequate or genuine explanation for the shortfall in FTX customer funds. Parenthetical question. And was the borrow-lend facility a potential justification that you had discussed with the defendant on November 7th, 2022? Answer, yes. Question. And what had you said to the defendant about that? Answer, it was not supported by the facts. Question. And what was his response? Answer, he acknowledged it. Well, that sucks a lot. In interviews, Bankman-Fried also tried to distance himself from the misconduct by falsely claiming that he was not running Alameda, that he had not been involved at all in Alameda trading for years, and that he was walled off from Alameda trading decisions in 2022. Again,
I feel like
citing
that was
transcript.
not
Truthful?
what's the word? True.
Yeah. Citing to the transcript, he, of course, ultimately admitted otherwise on the stand in the face of irrefutable trial evidence. The prosecution lawyers, I think they have held back too much, but I do like the shade when they throw it. He also claimed that he did not, quote, knowingly commingle funds, end quote, and that he was aware of Alameda's debts to FTX due to a, quote, accounting mistake. End quote. More lies in the aftermath of FTX's collapse that were disproved at trial. I mean, I hate to say it, but dear government, please tell me more. Like,
Rob?
I'm sorry, it's SBF. It's SBF. I can't. With him, I can't. I have watched this thing unfold from the beginning. From the pre-bankruptcy filing to the bankruptcy itself to all the gaslighting he did in the media. I have watched this thing unfold leading up to that trial, and every statement he gave, every press release, all of it. So
Everything you think is the worst, he somehow comes back and
doubles down.
outworsts it.
I don't get it. Bankman-Fried also lied about his intent, publicly claiming, I did not ever try to commit fraud, but the evidence overwhelmingly showed that he did intentionally take money that belonged to others and that he lied about it. Well, that's that right there. That's fraud. Now we get to the fun stuff, the obstruction of justice. God, because what do you do when you get caught? What do you do when you get caught? Well, the signal thing doesn't really bother me, right? The use of signal, cool, no problem.
And the thing is having a retention policy is also fine.
Yeah.
Just also saying things like the reason why we have a retention policy is so that we don't get caught by regulators. Not fine.
And having a retention policy is also how you don't get caught with emails like this. Bankman-Fried said that FTX and Alameda employees, quote, should be very careful about what they put in writing, because putting things in writing was one of the primary ways that financial firms got in legal trouble, end quote. So there's that.
Yeah, that's a choice.
The witness tampering, because when you get arrested and you get released on bond under house arrest, here's what you do. Apparently, the Sam Bankman-Fried school of thought is I email prior employees of FTX, and I try to, quote, get them on the same page as me. Or I go and I leak portions of their diary to the New York Times.
That was really gross.
To what? Slut shame them?
Yeah,
Like
that was exactly it.
Cool. Very cool. While on bail pending trial in this case, Bankman-Fried twice attempted to tamper with witnesses. You see, this is the thing, that all these things come back up. And I don't understand why the government takes this one so lightly. Because the judge in this case, when the first time occurred, the judge said, do you want me to lock him up? Like, do you want me to lock him up? just say it. I will. And the government's like, nah, we don't need it. We're good. We don't need it. Second time, the government's like, can I please lock him up? And the state's like, yeah, you can do that now.
I'm
Why
not
are
going to
you
fault
not?
the state for showing some restraint.
Maybe that's my personal thought coming in on this one. On January
I mean,
15th.
I just wish the restraint sort of went for everybody. Because if Bankman-Fried had like knocked over a liquor store, I don't think that they'd have shown him the same restraint.
No, they wouldn't. They really wouldn't. Which also has kind of bothered me. Like, he got the kid gloves a lot. He got released on bond, and the bond was posted by one of Stanford's acting administrators. The other bond was secured by a house that's half owned by Stanford and his parents. And you read the letters that we read through last week. If you want to see my brain literally explode, go watch last week's FNF. Like, go watch last week's FNF. Like, I could not believe what I was reading in his sentencing submission. His sentencing memo was, like, I've seen abusers gaslight. That was top tier, man. That was gaslighting like I haven't seen before. So, going into his post-arrest conduct, because this is post-arrest, when he's supposed to be on his best fucking behavior and not contacting witnesses, on January 15th of 2023, Bankman-Fried contacted the former general counsel, Ryan Miller, a cooperating witness and also someone who was originally thought to be charged, over Signal and by email, saying, writing in part, quote, I would really love to reconnect and see if there's a way for us to have a constructive relationship. Use each other as resources when possible, or at least vet things with each other. End quote. And suggested they speak further by phone. Bankman-Fried and Miller had not spoken since the bankruptcy more than 2 months earlier, and the government had already informed Bankman-Fried of its extensive investigation. Miller, through his counsel, informed the government of his reach out, and the government brought the matter to the court's attention. The court stated that on its face, the message, quote, appears to have been an effort to ... sing out of the same hymn book. End quote. And expressed concerns at that time that then existing bail conditions would not be sufficient to prevent witness tampering. That's what I said earlier. Can I please lock him up? The court imposed more substantial bail restrictions, including restrictions on the defense use of electronic devices. This was the training wheels on the laptop. Like, he was allowed certain sites, not the hub or anything like that. He could see news. He could
Which
access
hub are you referring to?
You know what we talked about it back then. His laptop became a bona fide brick where he couldn't communicate with anything other than news media.
I would have been super amused if he'd actually put down in his filings, because like he gave a list of things he wants to see.
Yeah, he did.
I would have been super amused if he'd been like, I need some porn.
I mean, I don't know. The thing is, we did learn from his sentencing memo. He doesn't experience pleasure from anything, although he does experience great joy from other things. So we don't really know where he falls on.
He doesn't experience pleasure from things except for the things from which he experiences pleasure.
That was quite literally the synopsis of his last filing. Like,
fraud is one of the things that seems to
I don't know.
And
if people think I'm being harsh on SBF, okay, go elsewhere. He deserves it. Despite these warnings, Bankman-Fried again attempted to tamper with the witness in July of 2023. This part really pissed me off. On July 20th, 23, the New York Times published an article entitled, quote, Inside the Private Writings of Caroline Ellison, Star Witness in the FTX Case. The article quoted from private electronic journal entries written by Ellison, but in Bankman-Fried's possession, that describe her feelings and insecurities with respect to her work at Alameda and her personal relationship with Bankman-Fried. This was so fucked up. I This was so messed up.
Mm-hmm.
He took her diary, like her biggest insecurities that he had private access to, that he did not tell her he had access to, and he leaked it to the damn New York Times.
Yeah, I mean, at least leak it to a good newspaper.
Mind you, here's the thing, New York is the jurisdiction where this was being tried. So good for you. Way to go. Double down on that asshole behavior. After Bankman-Fried's counsel confirmed that Bankman-Fried was the
He's
source
got
of
no
the
other
private
behavior.
documents.
That's his problem.
Yeah. After Bankman-Fried's counsel confirmed that Bankman-Fried was the source of the private documents, quoting the article, the government alerted the court that Bankman-Fried had provided private and potentially embarrassing writings of Ellison, his ex-girlfriend, former CEO of Alameda, and cooperating witness. This part, it's the ex-girlfriend, former CEO who he's trying to cast blame on, and cooperating witness to the New York Times in order to discredit her, paint her in an unfavorable light, and influence a future jury's perception of the case and the public at large. In a letter to the court, Bankman-Fried claimed he had done, quote, nothing improper, end quote, by covertly leaking Ellison's writings, but agreed to an order limiting extrajudicial statements about the case. Bankman-Fried also asserted that he had merely given, quote, comment on a story in progress, end quote. Bro, you did
You are the
little
story in progress.
more than that. Reviewing data from a pen register on Bankman-Fried's phone and email, however, the government learned that over the period of several months, Bankman-Fried had sent over 100 emails to and had over 1,000 phone calls with members of the media, including 100 phone calls with one of the article's authors. That's a lot of fucking time on the phone.
How did this guy not have a burner?
He wasn't allowed to. This is while he is on pre-trial release and conditions.
Yeah, but it's not like he's behaving.
Fucking gall. The gall. The audacity. Of course, Bankman-Fried's contacts with the press, regardless of the volume, were not inherently problematic and did not form a basis for a revocation of bail. Rather, the frequency and nature of the communications belied Bankman-Fried's factual claim that he had merely given, quote, comment on a story in progress, comment over the course of 100 phone calls and 1,000 emails. That's more than comment. That's a fucking prequel. That is God, pick a fucking word. Oh my God, I hate this man.
Or regular word.
I don't like this person. I have trouble like reporting. I have trouble talking about his case because of how much I know about it. Rather than the attempt to interject unfavorable information about Ellison into the press and turn potential jurors against her. At a conference on July 26th, the government requested the court revoke Bankman-Fried's bail and order him detained. Ian, can you take on for a second?
Yes. Once I figure out where we are. After hearing, I'll just start at the top. After hearing from the parties, this court found that there was probable cause to believe that Bankman-Fried twice committed attempted witness tampering in violation of 18 U.S.C. 1512 sub B, while on pretrial release, giving rise to the rebuttable presumption under 18 bunch of stuff that no conditions would assure the safety of the community. This court found that the presumption had not been overcome, and that in light of Bankman-Fried's continued evasions of his pretrial release conditions, Bankman-Fried was unlikely to abide by conditions of release. The court's revocation of Bankman-Fried's bail was affirmed on appeal, and therefore he got to live in a tiny little box. The Second Circuit held that the record supported this court's conclusion that there was probable cause to believe that Bankman-Fried attempted to tamper with two witnesses in violation of 18 U.S.C. bunch of numbers, and specifically that he acted with unlawful intent to influence those witnesses. The circuit, end of stuff I can read.
Well, this is the part too, because it's not just that the Second Circuit said we defer to the trial court. They actually said there's enough there. Like they went to the merits. So now we get to the perjury, the defendant's perjury. This is some.
It's
This
like,
is some. Bankman-Fried
and
also
now the
obstructed justice.
perjury is.
I know, like you don't really see this in. Honestly, the government will be quite like liberal in throwing around misstatement, the word misstatement or misspoke or obfuscated, or they'll use a lot of words. You don't see the word perjury tossed around a lot in a sentencing report. At least I haven't. But
It's one of those things where you don't pull the trigger unless you think you're going to hit.
you better have it. Like you better have it.
It's
Bankman-Fried-
you better not miss if you're going to pull that trigger.
No, the thing is, SBF testified, so you kind of know that they're not going to miss. Bankman-Fried also obstructed justice by giving
It's
false
hard
testimony.
to get to perjury, and I've seen prosecutors blow themselves up trying to say perjury, and the court's like, I mean, he was unreliable, but that's not perjury. Like, you don't get there.
But this might be. Bankman-Fried falsely testified that he did not know about Alameda spending customer deposits. That he did not know until late 2022 that FTX's code features were being improperly used to take customer money. And that he thought in November 2022 that his tweets were accurate and not misleading. This is why you don't let your client, or you try to dissuade them from taking the stand.
Well, when they're Sam Bankman-Fried.
Correct. Where was it? Hang on. Number of victims. Remember when Sam Bankman-Fried said there were none? And you and I had issue with that statement? The number of victims.
Specifically, we had an entire subscription with regards to that statement.
Yeah, kind of. We went off the rails for 30 minutes. The offense involved at least 1 million victims.
I'm bad at math because I'm a lawyer. Which is the bigger number? None or 1 million?
I'm going to say the million. It resulted in substantially financial hardship for 25 or more. 25 or more is the magic number they have to hit under the statute. So that references 25 or more. They know damn well it was more than that. First, as the PSR correctly indicates, the defendant's offense involved over 1 million victims, and the trial evidence indicated that at least one victim, BlockFi, experienced substantial financial hardship as a result of the conduct, blah, 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 declaring bankruptcy, yada, yada. So we've got more than one victim. So that's that. Because the offense involved in misrepresentation or other fraudulent action during the course of a bankruptcy proceeding, a 2-level increase is required. This is one of those things that I talk about quite a bit when it comes to bankruptcy that people don't get. Bankruptcy law is not sexy. It's not financial crime. It's not conspiracy. It's not the stuff. But it is one of those things where, one, when you file bankruptcy, you are opening the doors to every federal agency taking a look at your fucking books. Every one of them. The filing of Sam Bankman-Fried and I will agree on one thing. And it was that filing Chapter 11.
It better not be hairstyles.
No, it's this. It is Sam Bankman-Fried and I will agree on, come on. We're going to agree on one thing, and it's that filing Chapter 11 was a massive mistake from me as his attorney advising him. Because filing that bankruptcy literally said there might be a question on jurisdiction, but here's what I'm going to do. I'm going to go ahead and submit to the U.S. jurisdiction and open my books to the U.S. trustee and the trustee appointed by the court to take a look at everything. And when the U.S. trustee gets in the case, and when the trustee that gets appointed by the court gets in the case, the trustee stands in my shoes and can access all of my emails, communications, internal memoranda, all of the things that I did in that capacity as owner of the company. Bankruptcy is never the actual underlying fraud. It's what leads to the frauds. It leads to all the frauds.
Sometimes people do frauds in bankruptcy.
Oh, they do. But it's never like the sexy charge. But what it is the bankruptcy always opens the door to that sexy charge. Like I use the Real Housewives of New Jersey, which Emily's in the chat, she'll recognize this. Real Housewives of New Jersey, Teresa Giudice and Joe Giudice, right? So they got busted for mortgage fraud. How did they get busted? Because they filed for bankruptcy. And their bankruptcy schedules listed creditors and assets and income that wasn't disclosed in their mortgage loan applications. So their bankruptcy opened the door and opened the big window into all of the other fraudery. So it's like, hey, now the government has access to all your shit. So conduct outside of the U.S. and sophisticated means, because the defendant deliberately located FTX outside the U.S. to evade law enforcement or regulatory officials, because a substantial part of the fraudulent scheme was committed from outside the United States, and because the offense otherwise involved sophisticated means, a 2-level increase is required. Like, we are just, all the increases are occurring, everything, all of it.
I mean, I wish him a very merry high score on sentencing.
Oh, Emily, you and I could talk for days on this. Like the Joe Giudice and that bankruptcy filing was literally saying, hey, DOJ, I'm here, like charges, like just come on. It was every contractor scheme you could imagine. Anyways, the defense challenges to the guidelines calculation lack merit. In his sentencing submission, the defendant makes several challenges to the guidelines calculations set forth in the PSR. Specifically, he challenges the calculation of the loss amount, the enhancement for fraudulent action in the course of the bankruptcy proceeding, the enhancement for conduct outside of the United States, the gross receipts from a financial institution enhancement, the abuse of trust enhancement, and the obstruction of justice enhancement. While all of these objections lack merit, it bears noting that with the exception of his challenge to the loss amount, none of his other objections will affect the calculation of the total offense level, which would be 43 with or without those enhancements. Well, you know, if you're going to throw shit at the wall and throw all of it.
I mean, I don't think they're throwing shit. I think they're, I think in this case, they're throwing knives.
They don't believe. Well, no, the government is. What I'm saying is,
oh yeah,
yeah, with his submission.
Yeah, government came to ruin somebody's day.
I want to get to the. Hang on, give me 1 second here. Calculation. Scroll. Oh, here we go. The defendant's assertion that the loss amount for FTX customers is 0 is meritless. For those of you who don't recall, yes, Sam Bankman-Fried did in fact argue in his sentencing memo that there was a $0 loss figure for customers in FTX. The Ontario Teachers Union, I am sorry, you did not lose anything. You are fine. Nothing was lost. You're good. Those pensions.
Nothing of value was lost.
Nothing of value. Nope. Nothing of value was lost. The defendant does not seriously dispute any of these numbers or the evidence supporting them. Rather, he argues that the actual loss should be estimated at 0 based on developments that have happened long after his fraud was exposed and his company's declared bankruptcy. The sole basis for the defense argument on loss amount is a statement by counsel for the debtors in the FTX and Alameda bankruptcy proceeding that FTX customers and creditors, quote, will eventually be paid in full. You see that like little eventually part?
That seems to be doing some lifting in this.
A little bit. The defense arguments rely on that representation, however, are fatally flawed, both on the law and the facts. First, oh God, that was fast. As a legal matter, any potential recovery to victims in the bankruptcy proceeding should not be used to reduce the loss amount for purposes of the guidelines because reasons. Just because someone has to go through the back end of bankruptcy and receive all the money 5 years down the road doesn't mean they didn't experience loss or hardship because of the original criminality. There's a logic part there, like we just lost it. Yeah, criminality meant loss. Just because you get it back 5 years later at a different value doesn't mean that you didn't lose anything in the first place. So I am mad. I am mad. Why does he do this to me? I don't like it.
Because he does it to everybody.
I don't like it though. Like this is one of the only cases where I really get
Where you just like actually are like, I think this guy needs to suffer like
more
actual pain.
jail, like more jail, more of the more. And it's like, I want to be an attorney on this case arguing in opposition to this. Like, I want to make these arguments. On the contrary,
I just find myself wishing him a very merry, large cellmate.
On the contrary, as of this date, nearly a year and a half after FTX her bankruptcy and months since the defense conviction at trial, his victims have received no recovery and there's no timeline for when any such payments will be made. It takes a set of balls, lady balls, male balls, I don't care where you are, but it takes a set of balls to look at a court and say they haven't suffered anything when the bankruptcy filing was November 9th of 2023, and we are now 2022, and we're now March of 2024, and not a single dollar has been paid out of the bankruptcy. Like, that's a set of stones.
Yeah, I mean, I feel like that is almost like we're giving him credit there.
Oh, you're saying giving him credit for having stones?
Yeah, I mean, he's just an ass.
Yeah, it's pretty bad.
I mean, I guess his lawyer has some chutzpah.
I could not have written that. I could not have written his filing. There's no way I could have written his filing and filed that thing in good faith.
And you know what? If I was at a firm and somebody else wrote that for me, because like a lot of ghostwriting happens at a firm, and was like, here you go file this, I'd be like, no. It's the meme of the Grinch going, no, with his lips sticking way out. Because
yeah. There's a significant difference between the defendant's claim that customers will get all their money back or get all of their money, and the debtor's more measured statement that it hopes to return 100% of their allowed claims over time. Oh, shit. The allowed claims part is also a caveat.
That's doing a lot of lifting too, isn't it?
That's a lot of work. That's doing a whole lot of work. Because some of those claims are disallowed because if there's transfers that are made in that period, the 90 days prior to filing, like there's a lot of work being done by the allowed claims part.
Mm-hmm.
So, yeah, that's something. Wait, Ian, remind me where the part is that I'm looking for. The one that his big plan.
That is in the exhibits.
Okay, we'll get there. I gotta find.
Yeah, I think it's Exhibit B.
That's SBF's. Come on, US. Oh, they did it as one document, so it should be in here.
It depends on where you downloaded it.
Hang on. Either way, we'll go. Blah, blah, blah. Securities fraud case. Hang on. Let me go back to the top. It'll help me scroll.
The other thing is, if I'm a victim and I'm reading SBF saying, "Oh, everyone's been already made whole," I'm like,
Obstruction of justice. We were right about, hang on. The nature and circumstance of the crimes are extraordinarily serious. Bankman-Fried implemented, perpetuated, and concealed a multi-billion-dollar fraud scheme that victimized tens of thousands of victims of fraud, in which FTX customers and investors and Alameda's lenders suffered actual loss of at least $10 billion. For many reasons, the serious crimes call for severe punishment. One, aggregate losses, etc. No, I want to go to forfeiture. That's what I want to do. Hang on. Forfeiture. That's victim compensation. The court should order forfeiture. The court should impose the proposed forfeiture money judgment. The number is derived as follows. First, the court should direct the forfeiture of $8 billion. That is billion, right?
"Oh yeah,
Yeah, $8 billion. That's a hell of an amount of money, which is a conservative estimate of the proceeds of the defendant's wire fraud and conspiracy to commit wire fraud on FTX customers and the property involved in his conspiracy to launder the proceeds of that wire fraud." You guys remember we discussed the forfeiture part and we pulled up the lovely photos of the Bankman-Fried quote unquote condo.
oh,
And
you
the-
mean his
and the-
little hovel, the
and-
garret
and-
that he was living in?"
and the yacht, and the condo or the house, the modest home that the parents lived in, the $14 million home.
And him talking about how he had the smallest room in the apartment.
But it was this, Ian, it was the smallest room. It was the smallest room. And he didn't enjoy it. He didn't enjoy the room. You know what? If he likes small rooms, he's going to be fine. He'll be
That's
okay.
the thing. I think that they can get him the smallest room. And he complained that he didn't have a bathroom.
That one. Yeah. And this room that he's going to get, it will have a
It's going to have a
bathroom.
bathroom.
It will. It will be en suite, which means literally next to his bed. Like literally next to his bed. So
I also wish him a very merry plumbing backup.
So it does, Emily. It has a bathroom. It's an ensuite bathroom, and it comes complete with potpourri of your cellmate's expressions.
Expressions? I don't understand, Rob. Explain more.
Well, dogs express themselves. They have glands in there. I'm speaking like puppy and dog now. Like they express themselves with sense. Yeah, it's an ensuite bathroom. It's gonna be lovely. It's stainless steel. Stainless steel appliances are in now, Ian. Stainless steel appliances are huge. Like,
and he'll be in too.
Yeah, well, stainless steel appliances are a big deal. So he will have a state-of-the-art stainless steel toilet. It might not have a toilet seat on it though, but it will be stainless steel toilet with working plumbing and a stainless steel sink.
Working plumbing not guaranteed.
Is there a home warranty? I think there's a home warranty.
But also, his toilet is also a messaging system.
Oh, do tell.
Are you not familiar with the concept of a kite?
Go on.
Inmates will tie messages to string and then run it through the toilet system because the toilets are connected from one room to another. And it can be a way of them sending messages from one cell to another. Messages and small packages.
My thing was, I thought he was going to take up winemaking, like toilet wine.
I mean, he might do that as well. He does seem to be a bit of an entrepreneur, you know.
He is, and he could probably get a lot of people to invest
in toilet wine futures.
In toilet wine futures, he can create a whole market. The IPO will be huge. Oh my god! So
I feel like we're terrible people, but you know, Bankman-Fried is an even more terrible person.
Michael deleted, you win. I'm sorry, you win. The shitty way to deliver messages. That was solid.
I mean, it is.
And I chose solid accidentally and didn't realize what I said until I did.
He's lying, folks. He realized it.
Pruno and beef stick trading will happen. Like, you know, but I'm sticking with the stainless steel. The stainless steel appliances that's the selling point for me. So small room, stainless steel appliances, great resale value. Probably get a couple years for it. Like either way, phenomenal. As funds that have been obtained through the false statements and promises and then misappropriated, they are plainly proceeds pursuant. Yeah, they're proceeds. The fact that he tried to say they weren't proceeds was a fucking joke. The total of $8 billion also represents property involved in the defense money laundering. The reason the FTX had such a deficit was that the defendant and his co-conspirators had agreed to launder the funds through Alameda. And they did effectively. They used the funds. The money was like there is no other source of the money that they had to buy the condo, the yacht, the other condo, the house, and the other things. Like, that was the money. That was the money. It was all the money. They took the money from one place and they put it in the other place, and they used the money in the other place, and they bought all the stuff. But now we're supposed to not think about like the buying of their stuff because he didn't like the stuff.
Rob, you're making him sound like some sort of criminal.
I don't think I've ever argued this like hard against a defendant. Like I just can't with the bullshit he tried to pull in that sentencing report. Okay, yeah. So more forfeiture. Give me all the forfeiture. The defendant, however, asserts that he owes no forfeiture. Oh, this part, yeah. The defendant, however, asserts that he owes no forfeiture because, quote, customers and creditors will receive a return of their funds via the bankruptcy. This argument is factually unsupported and legally wrong. Nice sentence. Nice sentence. Way to go. Starting with the facts, as discussed above, it is far from certain that FTX customers and lenders will be made whole, and the bankruptcy proceeding will almost certainly not cover losses by FTX's equity investors. Here's one fact that I think the government should have stated. One, the trustee gets a cut of whatever they bring back into the estate. That's how the trustee gets paid by marshaling assets of the estate back to the creditors. Like that's their compensation. They do the work to bring the money back in, to claw it all back, and they get to take a cut off, which means that by its very definition, let's say the trustee recovers 100%. There's a cut that comes out. The creditors don't recover 100%. So, as a matter of law, there is no basis for reducing the forfeiture judgment based on repayment to victims in bankruptcy. I agree. For money laundering based on money-laundering-based forfeiture under 18 U.S.C. 982A1. There is no suggestion in the forfeiture statutes that repayment to victims could reduce the judgment. These statutes are really harsh, by the way. They really are. Indeed, 982A1 contemplates the opposite since it is based on the property involved in the money laundering. Scrolling forward. The same is true for wire fraud-based forfeiture. Wire fraud forfeiture, by the way, I know Emily's talked about this before. They just take all your shit. Like, they just take everything. Like, they just take it. There's no question. There's no nothing. The statutes give damn near unilateral, unquestionable authority for them to take the shit.
Good.
Yeah. Well, not good in some cases. In this case, this is the one case as a general rule, I
do not believe that Bankman-Fried should have any shit.
Well, as a general rule, I hate forfeiture statutes. I think forfeiture statutes are really, really, really overused. I think they get abused left, right, and center.
I got no problem with criminal forfeiture in a situation where it's like, dude has taken this, like this is a situation where we've got dude has taken the stuff. We're just getting the stuff back.
But the forfeiture statutes in the U.S., forfeiture in the U.S. goes so much further beyond that. Like, they can go and get everything.
Oh, I know, and that's BS. But like the thing where they're like are allowed to shake people down at, on their way to places, that is BS. But yeah.
Oh, this part. Give me the shade, government. I want to hear it. The defendant. Oh my God. I will never say that sentence again.
Do you feel a little dirty?
Who am I? What is going on? I don't like this. It feels wrong, but it just feels right. I don't know. I don't like this. It's like a.
This is how they get you, Rob. Next thing you know, you'll be at the ATF booth wanting to shake hands with people.
No. I don't like it. I don't like it. It's uncomfortable. I don't like it. Make it go away. Okay. Emily, forfeiture goes hard. Yeah, it does. It's no joke. The statutes are remarkably aggressive. The defendant next asserts that, quote, none of the accounts identified for forfeiture were for his personal benefit. Oh, this is my favorite part. Were not profits, quote, enjoyed by him, but rather maintained on behalf of the companies and therefore not subject to forfeiture. Just here we go. This is legally and factually wrong. While the word, quote, enjoyed, end quote, is found in Hallnagel, interesting case name, the law is clear that the government can forfeit corporate assets based on the defendant's crimes when those assets were maintained through and on behalf of a company the defendant, quote, extensively controls or dominates, such that money paid to the corporation was effectively under the defendant's control. You mean like when the company buys a house for your family, or the company buys the condo that you live in, or the yacht that you sail?
Is yacht the correct pronunciation?
No, but I'm using it from here on out, just period. I love the phrase yacht. It's yacht. Sounds so much better, right? Yacht. Oh, the plane. Don't forget the plane. I did not forget the plane. I didn't forget the plane. Yacht sounds more assholey in this. Like,
that is fair.
It's appropriate, right? Like if I'm going to be the prick that talks about the his like vessel on the seas, I want to call it a yacht because it's his. The trial evidence, of course, established that the defendant's control and dominance of FTX, Alameda, and its affiliated entities. It did indeed. He had a whole lot of control.
Not self-control.
No, none of that. None of that. Finally, the defendant asserts that the court should order no forfeiture because he is, quote, no longer has custody of the accounts identified for forfeiture in the PSR since the government seized the accounts. Oh, this is my argument. I made this last week. This is utterly meritless. There's no authority even suggesting the government seizure of assets traceable or involved in a defense crime somehow precludes the government from seeking forfeiture of those assets, of the defense interest in those assets. Indeed, the forfeiture laws expressly authorize seizure as part of the forfeiture process.
And I mean, this argument makes no sense from a fundamental level. Like, the government can't take these because they tried to take them.
Yeah, like the seizure part and the forfeiture part. Like yeah, you seized them, and therefore you currently possess them, but the government has not ordered that you have them yet. So now you have to give them back.
Yeah. I don't know. I'm starting to think the Sam guy might not be such a great dude.
This is why I love talking. Like, I honestly love having you on the streams when I talk about SBF. It's my favorite thing because I just it makes me laugh. Because you say things that both make me want to pull my hair out, bash my head against the table, but also laugh hysterically at the same time. And I can't really process how that emotion works. In order for the government to effect forfeiture of the specific property described in the preliminary order of forfeiture, yeah, this part. In order for the government to actually do the forfeiture thing for the things they described in their preliminary order, the court has to actually order the forfeiture. So we might have this shit, but the court didn't say we could have the shit yet. So we need the court to say we can have it now.
We want to keep it.
Yeah. We need the court to say we can keep it. Like that's the part. Like he says, no, but judge, they already have it. Nah, bro, we're just hanging on to it. Like we need the court to say we can keep it.
We want to not give it back forever.
I get.
Do you think he's going to get to watch his sports ball on pay-per-view in custody?
Fuck if I know. I don't know. If you know what this judge is and has been, I have liked this judge. I have very much. The judge is he's a hard-nosed judge. Like he's no bullshit. He didn't let them pull half the stunts. Like when SBF was about to take the stand, this judge excused the jury for the full half day and was like, no, we're going to preview your testimony because I'm not putting you on the stand and you spew a bunch of bullshit. So I like this judge also because the judge prior to looked at the behavior and was going, can I revoke the bond now? Like, can I do it yet? Like, you can let me? So I think a lot of the judge's focus is going to be on post-arrest conduct. I really do. I think it's going to be on the absence of remorse, the obfuscation of the underlying offense. And if I am this judge, I am focusing on the argument. I really am. I am focusing on the argument that he is making that there is no loss.
Oh, and I'm tearing him a new one.
I can't get beyond that. If you have the opportunity to sentence somebody, and one of the factors you have to consider is their ability to, well, you're opposed to recidivism. You want to say this person is capable of the corrective process, right? Going into correction, acknowledging their faults, doing their time, doing their punishment, coming out a different person or a better person, or at least acknowledging what they did was wrong and willing to contribute to society again.
Or at least willing to not do it.
Willing to not do it again, right? You're trying to dissuade. Ultimately, you're trying to rehabilitate. It's not really the case, though. You're just trying to dissuade. when I have a defendant that is facing a trial like this, and in the face of that trial, does all of these things. Oh, that reminds me, Ian, I didn't do the last thing. It wasn't their supplement, right? Or was it their supplement?
Where I found it, there was a whole bunch of like separate documents filed. So it was one of the like the exhibits to their filings.
Oh crap. Do you see there's a letter by some oh damn, who are these people? Hold up.
Are you seeing the Twitter messages?
No. Mukasey and Young, LLP.
Oh yes. I haven't
Do you
read
see
it,
this
but
one?
I've heard of it. I've heard that it exists, but I haven't read it.
Dear Judge Kaplan, this letter is respectfully submitted on behalf of defendant Sam Bankman-Fried in reply to the government sentencing memorandum. Are these the new appellate counsel? Yeah, this is them. No, this is the new counsel. This has got to be them, right?
Not sure. This is a different letter than the one I was thinking of.
No, yeah, this is new defense counsel. This letter was, there was this one that was filed on the 19th, and then they filed a second letter on the 20th. It's a lot of words, man. In further reply, so they did this one in reply, and then they did in further reply. Okay. The government's memorandum is disturbing. Market hostility. The memorandum distorts reality to support its precious, quote, loss narrative and casts Sam as a depraved supervillain. Holy shit. Well,
Y'all have lost the fucking plot, dudes.
it attributes to him dark and megalomaniacal. Wow. I don't get to use that in pleadings. Dark and megalomaniacal motives that fly in the face of the record. Dude, my guy, my girl, whoever's writing this, the dark and megalomaniac, those things.
Listen, if kryptonite exists, your client would be trying to kill Superman with it.
And those things I got from your pleading, not the government's. Like I got that from what he was saying, not what the government said. This is it makes apocalyptic prophecies of recidivism. Whoa. And adopts a medieval view of punishment to reach what amounts to a death in prison sentencing recommendation. That is not justice. Holy crap. I had not read this. Hang on. I realized I also did not share that with anybody.
I kind of feel like it will be an injustice if he dies anywhere else.
I'm sorry.
Other
I
than,
didn't
like-
share that. I thought I had that pulled up. That is my fault.
I'm glad to see you're not trying to blame my client for this one.
No, your client's asleep.
You know, unlike
So-
the other unjustified attempts to blame my client in the past for
Take it
things
easy.
like chewed cables, which were
take it easy.
probably
We're off the clock. We're off the clock. Mask is down, off the clock.
that was probably, you know, like one of the small children that was that was there.
Probably. Might have been. So we've got March 19th, and then we've got March 20th. So let's go back to this that I started to read without so rudely not sharing anything else. Blind reaction territory is where we are. Thank you. Yeah, Lay Drake, we are here. I am sorry. I can't.
Sharing is caring.
I I just read the first paragraph and my brain just like melted. So to rephrase or to restate, the government's memorandum is disturbing. With market hostility, the memorandum distorts reality to support its precious, quote, loss narrative and casts Sam as a depraved supervillain. I'm going to say it again. You get two looks. One, hair. Two, bald. Hair, supervillain. Bald, supervillain. Like there's no.
I mean, basically, he's Wish.com Lex Luthor.
Ian said it, not me. It attributes to him dark and if they use this word more than like 5 times, megalomaniacal,
Three times fast, Rob.
Megalomaniacal.
Megalomaniacal? Is that the word you're looking for?
Yeah, that. Thank you. Motives that fly in the face of the record. It makes apocalyptic prophecies of recidivism, and it adopts a medieval view of punishment to reach what amounts to a death in prison sentencing recommendation. That is not justice. No law. Section 3553 allows the court to consider that the bankruptcy proceeding will result in customers and lenders being made whole as of the bankruptcy petition date. Here's the problem. That doesn't account for loss on the money that they would have had in their possession from that date forward. Yeah. The truth is there were never losses. That was a sentence they said out loud. The money has always been available. Assets remain. They said that part too. Each victim quoted in the government's opposition will receive 100 cents on the dollar plus interest. Are they referring to the million? Like the million, or like the couple that the government like highlighted in particular?
The couple, it looks like.
This would be impossible if the estate's assets had disappeared in Sam's personal pockets, which they did. Like you're losing me, man.
Unless the government managed to somehow recover those from Sam's personal pockets.
I'm sorry. They have fucking lost me. Like entirely lost me. I've seen the money. Like you can't. Oh my God. This is so angry. This is so angering. The government concedes that the court can make credits against loss in cases involving collateral pledged or otherwise provided by the defendant. The government also refused to give Sam any credit for funds Alameda paid to FTX prior to the bankruptcy. You mean paid back that they didn't have access to because Alameda never owned the funds at all. Refusing to acknowledge that Sam's good faith effort to process client withdrawals. You mean committing the fraud, committing another fraud to repay the first fraud? Like taking assets from one company to another and then putting it back in the other company to pay off the fraud you did in the first place. The government sees only red, and so do I right now. As I read this, I am seeing only red. Only red. And I'm getting angrier.
Rob is going to choose violence in a minute.
I am so close, man. This is, and the thing is, they came out swinging. Fuck. Given that full repayment of creditor claims to the bankruptcy estate is inevitable. Inevitable. That seems like you keep using that word. I don't think it means what you think it means. Inconceivable. The government instead laments that, quote, nearly a year and a half was passed without any payment, and Sam has not provided any significant assistance in recovery efforts. But it has never been Sam standing in the way. Footnote 2. What is the footnote? There better be something here. Oh my God. It's the fucking pre-bankruptcy filing. Oh, it's the authority letter. Oh my God. That's what it is. Before they filed bankruptcy, they gave John Ray the ability to take the company to bankruptcy and to administer the bankruptcy estate. John Ray, who reorganized Enron, John Ray, who is in charge of the estate, they signed a letter giving him that authority prior to the bankruptcy filing. So this is Sam's version of like hitting the oh shit button and saying bankruptcy and being like, I wasn't standing in the way. God, we got to break something. So, oh my God. Delay surely would have been reduced if Sam had not been rebuffed in his repeated efforts to assist with identifying meaningful value in FTX. No. Like, full stop, no. Because we also have rather confirmed allegations that he was trying to access the system after the bankruptcy to move shit around. Like, that was... We had all of that evidence. Like we knew that was happening.
If I'm the judge and I'm looking at this, I'm just
burn, like just fire all of the sun, yeet. I don't have words to connect the two. I'm so mad.
I'm just going to be like, I've received sentencing submissions from Mr. Bankman-Fried as well as from the state. I am rejecting both of these because neither of them is calling for Mr. Bankman-Fried to be thrown into the sun.
This is the best comment of the night. It's my favorite comment of the night, I think. The last sentence we'll read. Can someone give me some water? I'm so high, I'm going to fall asleep.
That would actually be in character for Bankman-Fried.
And the government omits that one of the reasons the debtors have delayed finalization of the Chapter 11 plan is that they continue discussions with the U.S. Department of Justice with respect to asset forfeitures and other government agencies regarding voluntary subordination of government claims behind the victims. Yeah, here's the thing. The government has claims. We would like to put those behind those of the victims so the money is there. One of the forfeiture claims is the government has that money. They can then, give that to the estate, or the estate can pursue it. I mean, it's there. Thus, the same government seeking life in prison for Sam, because no one is yet to be repaid, is itself partially responsible for the delay. Oh, that's a good job. Let's see how this goes for you. False motive, hell bent on portraying Sam as a monster. Holy crap. The government makes repeated references to his, quote, unmatched greed. I would say those references, by what I have seen, are not false. And his supposed ruthless desire to maximize his personal wealth. I didn't actually read that from that. I saw unmatched greed and unmatched a lot. I didn't see like maximizing own. It's a seductive.
I'll give it to him. We can read between the lines on that one.
Sure. It's a simple seductive narrative. It's also a false one. One, I don't hate the writing style. I hate what is written. The writing style is good. What is written is bad. The word greed was never uttered by any trial witness. Effective argument. Good point. There you go. And the government snubs the people who have known Sam for years and tout his selflessness. The government also continues its conflation of corporate growth versus personal greed. Do they? They fixate still on Sam living in an expensive penthouse apartment. Yeah. While ignoring that he paid rent for his room.
To himself.
from money that he borrowed from the company that
Like,
wasn't his.
This is
Like,
accounting bullshit. This is not.
This- like you paid me, you gave me the money to hold on to, right? Let's look at the example I gave at the beginning of the stream. I have a client trust account. At some point in time during the course of that litigation, I will likely bill against that trust account, but it's not guaranteed, right? I'm going to likely bill against it, but not guaranteed. I can't use that client trust account and go and pay rent and say that, but I paid rent for it because I didn't earn that money. It's not my money. I don't get to do that. That's illegal. That's wrong. This is the part that I think is bothering me so much. He paid rent with money that he shouldn't have had. Like, that's the problem.
What is bothering me is that I can't do a violence. This guy just, oh.
Here's the other part, that FTX rented out corporate housing to scores of employees that they paid with money that wasn't theirs. And that the real estate was always an asset of the company, except it was purchased with money that wasn't the company's money.
Well, and he's making it sound like the company is some, like, you know, strange, you know, organization that he's got no connection to. Sir, that's you.
This part, this risk of recidivism argument, I have hated from his position, because here's the thing about white collar crime. White collar crime has some of the highest recidivist rates literally ever, because people that think they're too smart, or that know they're too smart for the system. They're going to find a way. You lock them up. What are they doing during that entire time? They're thinking about how to be smarter, how to not get caught.
How could I do it better next time?
Yeah, not all of them.
But Sam Bankman-Fried.
Do you think that giving this person access to a company, hell, let's say, for example, there's a charity that's like, Sam Bankman-Fried, you run this charity. Is that a good idea? Like, is that really a good idea? Do we really think that even with his time in jail, with this pre-sentencing report, do we think that that's going to end up well for anybody?
I do think it'll end up well for somebody. It's Sam. I think it'll end up well for Sam.
The government's recidivism discussion stacks conjecture on top of hypothetical, on top of supposition. Well, that's not bad. That's not a bad argument.
On top of a hat.
I kind of like. I want to use that sentence in another case. I'm going to use that.
Do not.
No, just
that is a bad sentence.
In a case where it's applicable. According to the government, it is conceivable that someday Sam may feel compelled to find people who may hand over their money, concluding that history could repeat itself. I'm going to say that's I'm fine with that understanding. Oh, offenders with no criminal history like Sam are the least likely to reoffend. Oh, really? Nor does offense level predict recidivism.
I know a way that we can keep him from reoffending.
All the jail. And offenders with a college education are less likely to recidivate.
And none of that stopped him from doing it the first time.
Let me tell you how well that argument's going to go over in New York. Like the whole college education, like less likely to recidivate. Like, yeah, that's going to go. It's going to go well for you. You're going to love it. The judge is clearly going to buy this. 100%. I get it. Yep. Judge is totally on your side. Don't worry. Read the room. There are many other reasons why Sam would not reoffend, including, oh my God, I'm going to vomit, including that he would sooner suffer than bring disrepute to any philanthropic movement.
What?
Oh.
Okay, cool. Let's have him test that by, suffering.
He would sooner suffer than bring disrepute to any philanthropic movement.
Cool.
What
Suffer.
a fuckstick. I'm sorry for the language. That was
I'm not. I endorse the language.
also totally warranted. Like I
endorse the language.
I'm sorry to any kids that are watching. I really unsupported claims and attacks. The government makes a host of other curious, unsupported, and exaggerated claims. They say that in cases of 200 million or more in losses, courts are typically imposed sentence of 50 years of imprisonment or more. That seems weird. Like, I get that part. Like, we're going to attack the sure. They also allege Sam shirked, evaded, and deflected blame. Well, he fucking did, belittling his repeated earnest statements to the contrary. December 22nd, proposed written congressional test. No, they're going to cite it too. Oh, no. Oh, no. You know what's funny about this? He made these comments from the Bahamas when he refused extradition. Like he submitted these comments and he was contesting extradition. He was like, I fucked up. And I'm so I'm dedicated as much of myself as I can to doing right by customers. As he was in the Bahamas saying, do not extradite, do not charge me. That was literally what he was saying. Submitting written testimony to Congress.
I hate him.
The government also takes umbrage with Sam's protestations of innocence and his temerity in putting the government to its proof at trial. No. There are cases where I will say that I don't like when the government says, think of the cost of them going to trial as a sentencing enhancement, right? Like we had to try this case. And if they had just admitted their guilt in the first place, we wouldn't be here, right?
Yeah, that's bullshit, but that's not what's happening with Sam.
That's not what's happening here. Like, this is one of the only cases, and I will tell you, this is the exception, not the fucking rule. This is one of the only cases where I will quite honestly say this is where this enhancement or this consideration is appropriate. He made them jump through fucking hoops. He tried to violate bail conditions. He tried to intimidate witnesses. He tried to contact other witnesses. He tried to leak to the New York Times. He did everything to make them work. Not because he was protesting innocence, but because he was trying to fucking tip the scales. Like, there's a big difference between someone who's defending and protesting their innocence from someone who's doing that shit. I had not seen this letter, and I'm getting angrier and angrier and angrier. Sam is hardly the first defendant to acknowledge accountability without conceding criminal culpability and to assert his base conduct. Not the same thing, my guy. Conclusion. At age 32, the government wants to break Sam Bankman-Fried. Let me just go ahead and flip that script. Sam Bankman-Fried broke himself.
And a lot of other people.
He had so many fucking opportunities. He had learned, wise, and intelligent trial counsel. Mark Cohen is not a joke. Mark Cohen is a damn good defense attorney. Kristen Everdell, damn good defense attorney. He had wise counsel. He had the best lawyers, the best people advising him. And you know what they said? Don't do the shit you're doing. And he kept on doing the shit he was doing. This is someone who not only looked at everything he had done, but looked at every person in the room who was telling him to stop over and over and over again. And he said, nah, I'm smarter. Even to the point where he took the fucking stand and testified, which was the dumbest decision he could have ever made. And you know what's even worse about that? The judge said, here, I'm going to let you preview this in front of me before the jury comes out so we can see how stupid this is going to be. So he goes out and testifies in front of the judge, like testifies in court in front of the judge. No one's there. There's no like jury there. And he testifies terribly. He gets slaughtered on cross. And he then goes back to his cell that night and says, and I'm guaranteeing you his attorney, Mark Cohen, came back to him and was like, you can't testify. You can't testify.
And he went,
no,
I'm a testify.
I'm going to do it. I'm going to do it. Right? I'm going to do it. The judge gave him how many different admonishments, corrections, actions, directions. The bankruptcy court, John Ray, he tried to join in the hearings, and every single fucking person tried to say, no, sit down, chill out for 2 minutes. And he goes, no, I'm better. I'm smarter. The government's not trying to break him. He broke him. Like, he broke him. They ignore completely his condition and vulnerabilities. Or he did. Instead, they urge menacingly that the sentence imposed must disable him from even being in a position where he theoretically could perpetuate a fraud. I agree. This is a horrifying interpretation of specific deterrence. In other cases, I would agree with you, not in this one. We have yet to identify a federal defendant convicted of a non-violent offense who served a 40-50-year sentence and was released. Perhaps because inmates suffer a 2-year decline in life expectancy for each year of well, that's an interesting stat. 2-year decline in life expectancy for each year of imprisonment. You should be arguing in favor of different defendants. Like, I feel like this argument would be more appropriately applied to other people.
Also, that's probably on average because a certain number of them get, murdered.
Probably true. Crushing Sam is in this way is unnecessary. Wait, who are they quoting here? Please tell me this is. Oh, I'm gonna be so mad. I'm so fucking mad.
It's a case, okay.
Carvajal, yeah, they've cited that to a lot. They have. John S. Martin, a former district judge, recently addressed the quote overly long sentences that are being imposed every day in our federal courts on non-violent offenders. He wrote that we have lost all sense of how horrible it is to spend even 1 year in prison, far away from family and friends and under constant fear of unprovoked attack by other inmates. This is a bad take, man. This is a really fucking bad take.
Yeah, they were talking about like drug dealers.
This is a bad take.
Drug dealers probably hurt fewer people than your client.
And even drug dealers, we're talking sentences that are in excess of this. This is a bad take. He concluded we could achieve greater deterrence by sentencing Bankman-Fried to receive 30 lashes on the street outside New York Stock Exchange. Well, not allowed to do that. It's not lawful anymore, like at all.
I actually don't think 30 lashes would be sufficient for
I don't either.
Bankman-Fried,
because he would take that and he would go back and he'd start investing again and doing this other shit. If we did so, there would be a hue and cry about the cruelty of the criminal justice system, but 100 years in prison, ho hum. Oh no, I'm not saying ho hum. I'm saying you did. Sam has lost everything and almost everyone. how many times did I fucking say it? How many times? By his own conduct. And I'm sorry, but the whole losing everyone, including Caroline Ellison, maybe when you take your ex-girlfriend or your girlfriend's diary and leak it to the New York fucking Times while she's testifying against you, maybe you shouldn't have the expectation that she's going to come running back into your arms when you do that.
Why is she not waiting for me?
I don't know if I can't.
Have we gotten to the critical point of F this guy?
Oh my God, I'm gonna lose my mind. Because they keep on arguing. They keep on arguing. Oh my God, they keep on doing it. They keep doing it. They just keep going. It's a 9-page letter. In addition, they're supplementing. You know what they're doing? They're trying to clean up the mess they caused by this 5-page letter. Like someone in the office, they got back to the office after they filed this, and someone goes, "What did you just do? What did you just do? Did you read what you wrote? Like, did you see it? Did you read it out loud? Because, what?" So they're like, no, don't worry. We'll fix it. We'll write a 9-page one. We'll write a 9-page one that clarifies what we were trying to say without all the inflammatory language. Here's the problem. The judge read the inflammatory language. Like the judge read what you wrote. So
And this doesn't fix it. This makes it worse. It's worse, not better.
It just give me. I want to remind the chat what his request was at the end of his sentencing report. His request was for time served. That is literally what he said. Take into consideration the time I've served in jail. End scene. Look,
You have opinions?
So many. So many. But we are 4
according
hours
to
into
Sam
the stream.
Bankman-Fried, this is just an urge for bloodlust.
We talked about this when what's her name? Elizabeth Holmes was sentenced. And she got 11 years by my recollection. And we talked about all the lives that were altered by her decisions and her actions. Here's the thing. Hannah Gutierrez-Reed altered a lot of lives by her decisions or indecisions or her behaviors. She did. She changed a lot of people's outcomes. Helena Hutchins, she had a daughter and she had 2 daughters, I think. Yeah, I can't remember. She did have kids though.
Yeah.
Those kids are growing up without their mother in the care of their father because of decisions that were made by Hannah Gutierrez-Reed. There are people that were traumatized on set, people that experienced the proximity to someone else dying by something that traumatic, people that had to witness the life-saving methods that were being performed, people that had to see that. And then every time they see a toy gun, I imagine every time they see a toy gun, they're going to have some traumatic stress that's associated with that because they're not around that. They don't expect that when a gun comes up, that's going to shoot.
Well, and there's a ton of people who are legitimate film armorers whose livelihoods have been like shattered by this crap.
Yeah. So Hannah Gutierrez-Reed altered the lives of several people. And the thing is, we try to punish in a fashion that recognizes her role in that, right? So the 18-month maximum or whatever it is, that's supposed to recognize that she didn't play a principal role. She played a role. And that there are other people in that chain that can share in that punishment. Where at the end of the day, the net
Well, and it
punishment
also
meted
recognized that
out.
she didn't mean to kill anybody.
Correct.
She
It was
just
unintentional.
super careless.
And it
But
wasn't
he meant to
knowing. It was,
steal money.
and
Like-
that's what drives me nuts. And Ian, I think you feel the same way. There are people that do things where their action has a consequence to other people around them. Let's take the worst case scenario ever, intentional homicide. Like intentional homicide, you shoot someone, you knowingly deprive, take away that person's life, right? You shoot them. Now, that person gets sentenced to life in prison. Take that to a financial crime. Let's say that you act in a way where you know this is this person's life savings. This is every dollar figure, every dollar they have.
Yep.
And you take it. You take everything that they have that they feel is worth living for. You have taken their life. You have taken their life.
Well, a lot of
Why?
people in this circumstance went from, I am going to be able to retire to, oh, am I going to have to work until I die?
Oh, I didn't know that that was one son. That's one son. That's fine. What I meant was there's a child involved. But depriving, or like what Ian said, like you take away everything that they had worked for, all of it. You take all of that away and you put them back at square zero where they are 70 years old and have nothing left. You've taken their life. You've taken their existence. You've taken everything about them away. Now, with financial crimes, let's multiply that by the number of people where that factual scenario plays out at. All the people, all their savings, all their livelihoods. How many lives does someone who commits, quote, white collar crime take?
Oh, you can impact a lot of people that way.
It's not just cash. It's not just money. It's a big fucking deal. And I hate that the arguments that and maybe that's why I was so emotional about all of this stuff, is I hate the arguments that we see where it's like the defense lawyers get up and they're like, it's just money. It's fungible. It'll come back to them eventually. The 80-year-old person who has the savings account that was invested in the Ottawa Teachers Pension Fund, they are a claimant in the bankruptcy case. And Bankman-Fried's lawyers had the balls to look at this judge and say, well, judge, they didn't lose anything because they'll eventually get it back. When?
I mean, the thing is, I agree with the sentiment that like money is less serious than like stabbing a guy, but it's still something. Like it ain't nothing, and it's kind of insulting if you're like, hey, yeah, this is no big deal, because it's like it is still a big deal. And one thing you got to be mindful of as a defense lawyer is to not step in it, because it's really easy to make some sort of argument that will piss off the court. And like, this is an argument that should piss off the court quite properly.
Yeah. Like, let's say the judge is me right now. Like me, I'm expressing a frustration that I have with white collar crime and how we treat it. That's a principle. Like, that's an understanding of the law. And I get how the black letter law is written and how I'm supposed to apply the factors, but I have an understanding of that application that reaches further than what that reading might mean to other people. Other people see dollars on pages. I see food in mouths. Other people see profits and proceeds of a lucrative investment company. I see a roof over a head. If they wrote that shit to me and I'm sentencing, where's the biggest book I have? I'm gonna throw it at the puffy haired head.
Not at Leo.
Alita. Good morning. I think it's morning. Yeah, good morning. Money is also a representation of someone's hard work and the time they spent away from family and friends. Yep. You are taking all of those things from them. I hate people that say robbery is a victimless crime or that this shit is victimless. Like, no. Like, I don't like the classification of violent and non-violent when we talk about things that are like this significant. I think that trying to classify those things in categorical things of violent and non-violent actually does a disservice to the people that are victims of violent and non-violent crime. I get that you kind of have to do it. I don't like it. I hate it. But we're going to play catch up because I've been streaming for 4 hours and 25 minutes. I had a full work day, a full and a half work day. I yelled at a lot of people. Fought back.
Parts of it were also hard. It wasn't all fun.
No, I don't like yelling at people. It's not a fun part. Mountaineer, thanks for becoming a member. Turf Smurf, member, thank you. Truth Seeker, thank you for becoming a member. Gen V, thanks for becoming a member. And Moon Dragon, thanks for becoming a member. Yellow Pill NP, I had my wisdom teeth yeeted last Friday. Oof. So I watched with the replay crew. I was doing saltwater rinse when Ian posed a question regarding hand motion. I choked to death. Well, here's one constructive comment. If you have a surgery and you are not allowed to like give an outburst of either anger, laughter, frustration, or like just elation, maybe wait until you're able to do that, because Ian makes a lot of comments that yield a lot of responses. 99% of them are hilarious. The 1% are audacious. Like, but it's always going to get a response. Matilda, hello from the Netherlands. Hello to the Netherlands. Laura M, can't wait to read Leo's. Oh my God. Oh, Alita, you missed this part. Oh, shit. I have to say it again, don't I? Now I have to explain it again, don't I?
No, just
Okay,
leave
good.
it.
I'm going to leave it.
Leave
Alita,
it.
scroll back
Alita
to the
like,
beginning.
What the hell?
Scroll back to the beginning. Just. Last up, person number 27. Oh, please, only Wednesdays are 1 hour with EDB. Love you all and your neurodivergent brains. Wednesdays are 1 hour with EDB. That's because she's recording her podcast. And no, I have sat in on those members only. Like, no. She goes for 2 or 3. And when she's trying to set up like the recording, she's like, I'm about to record the podcast. She sees something in chat and goes on a 10-minute tangent. No, I love my tangential friends. I love, and not tangential as in they're tangential to me. I love the people in my life who take tangential thoughts and just explore them. Lost in a crowd of 3. So you're saying the EDB Runkle et al. Together on one stream would be the same thing as feedback loop? Nope.
Yes,
It's just, it's not. It ends up being like the train to nowhere. I did a drawing once, like where I did the squigglies that like ended up like to nowhere. And that's the best example. Light Queen, my daughter is ADHD, but I've only really recognized my own ADHD from hearing all of you talk about it. That's the point. I mean, yeah, like learn about yourself, whether it's ADHD or not. I'm not like critical on the diagnosis part, just recognizing how your brain works and recalibrating your life to kind of work with that is great. So try your best. Nanner, favorite streams ever are the 3 of you off the rails. Oh, they're great, but I will tell you, hosting those is exhausting. And I've been on with Emily when she has played host, and you watch her end the stream, and she is as exhausted as I am.
I am running out of gas.
Okay. I've got 20 more. You can jump off anytime you want, buddy. You want to jump off?
No, I'll stick around for a bit.
Okay, it's your call. Tamara Cartwright Loeb, diagnosis came in yesterday entirely thanks to you too. Autism and ADHD. I'm 59 and so much suddenly makes sense. I now know what's wrong with everyone else. That last comment, I kind of like I now know what's wrong with everyone else. Solid. Thank you. Thank you for sharing that. Book Dragon KSC, my ADHD boys, thank you for all the advice you give. Thank you. Thank you very much. Those comments, by the way, to Ian, myself, Emily, and everyone else who talks, like those are the most significant ones to all of us. Tina Wright had to say goodbye to a best pup. Thank you for this. Rainbow Bridge is a tough bridge, but we have to think about the good things they brought to our lives and the companionship they gave without any expectation of anything in return. XCDA, while I love to learn the law, my absolute favorite parts are the offshoot discussions. XCDA, I know that you love them and they're fun. I do love them. Love all of you. Thank you. Lynn, love all three of you guys. Thank you for being you. Never going to be anything different. Made that promise a long time ago. Chugi Show, I have issues with witnesses being allowed to testify. Witnesses being allowed to testify? I guess
you should be able to testify.
I guess if they testified before or if they inconsistent, I don't. Trying to figure that out.
I'm not sure I get it, but that's okay.
Kimmy Locker, bye to those people. I'm here for it all. Oh, the people that are making the comments about like I talk too much or ramble. That happens. Amanda Lang, this is where we feel at home, fellow Chaos Gremlins. Chaos Gremlins is my new thing. Suzanne Martin, hey guys, my grandson is 11 and brilliant, but he was just diagnosed with ADHD. He's having a rough time in school. Teachers don't understand him, and I need some guidance. Patience. Find whatever techniques you can outside of the home to release outlets, frustration and stress, so that when you come back in the home, all of your patience reserves, like everything you've got in the tank, is empty and ready to take on, because there's going to be a lot of frustration he's going to express. And part of it is calming and finding his language and what he speaks and how he understands learning. Some are kinetic, some are verbal, some are auditory, some are visual. Some are all four combined. So test methodologies. And stick up for him to the teacher. Don't be afraid to push back. Anything to add? No? Good?
Yeah, patience is a good one. And just it's hard to figure out. And there's going to be, false starts and backsliding and so forth. So, yeah.
Don't be afraid of the teacher. And there are lawyers, like my law firm does it too. Educational lawyers, because we didn't used to need them. But now school administrators like to put up like these big roadblocks, and they put up a bunch of bullshit in front of you. That if they push back, like push the teacher, don't be afraid. And if they do push back and they try to make life miserable, start talking about lawyers about rights. Like education is its own subsection in the code for a lot of states. So there's things you can do. And right from that, here we go. John Common, thank you. It's okay, Rob. I've accidentally peed on my cat.
Don't do that.
Yep. Kate, maybe. Always so happy to see my favorite duo. Love you both. Love you too. Vincent Rando, can you imagine what was going through John J. Ray's head reading SBF's proposal? Screaming and punching and hitting. DSN, thank you for the super sticker. Yellow pill, thank you. Not so stainless steel toilet. Probably. Lady Alessandra, thank you for becoming a member. Bureauin, SBF needs a cellmate with IBS. Oh, that's brutal. Carson Pratt, thanks for keeping me company on night shift. Back
Yeah,
to
that is-
Moon Clips.
That's
Go ahead.
unfair. Like, if you've already got IBS, do you really need to be stuck with, with SBF?
Sam Bankman-Fried. Oh my gosh. Didn't see that take coming. Carson Pratt, thanks for keeping me company on the night shift. Back to Moon Clips. Another cool feature is some revolvers use them to allow things like 9 mil in 357. I don't know if that would be recommended. I think that, like, I'm not going to say that that's like a safe use thing.
Yeah, those seem to have a very different profile.
I would very much say that you should use the caliber munition for the caliber of the firearm. Like, don't mix and match. Like, but
if you're going to
I
mess
see the
around,
point.
let someone else test it first.
And I can take a look. Thank you, Carson Pratt. Vincent Rando, this is what happens when one of the top courts in the world at tackling financial crimes is getting the book thrown at you as their highest priority. Oh, I want that sentencing. I hope it's going to be interesting. Mom Betts, thank you for the gifted memberships. Rosebud, thank you for the gifted memberships. Marbled Cat, how is the filing not malpractice by the lawyers? It's not. Like, they're arguing the best they can for their client, and they're using the best interpretation of the facts to their advantage. That's what they do. I can't actually fault the lawyers for doing it, because they are pushing the boundaries of what they're allowed to do. They're supposed to. It's just frustrating to read.
Yeah, none of that's going to be malpractice.
No.
Hannah's lawyers might get yelled at, but they're not going to get sanctioned.
Yeah. Lewis, could this hurt SBF more? Lack of remorse is clear. I think it does. That's my opinion.
I think there's a real possibility that it just pisses the judge off.
I'm right there with you, bud. Like 100%. I'm pissed. You're pissed. The judge sat through this trial and the pretrial stuff. Lisa R., I didn't realize Enron people were involved. Somehow that makes it worse to me, because I was born and raised in Houston. The Enron bankruptcy harmed so many families. These people don't change. No, Lisa, there's a clarification. John Ray,
the guy who helped unwind Enron.
Unwind it. Yeah. John Ray helped to unwind the shit storm that was Enron. Like, the bankruptcy filing that's caused by all of the shit that was happening back then, right? The bankruptcy
He's
filing,
the guy trying to get the money back for people.
Exactly.
From Enron.
When it goes to the jurisdiction of the bankruptcy court, the court's like, we have oversight. We're not going to allow the same bullshit to happen. We're going to use the tools here to reorganize and start paying people back. And we recognize that's a lengthy process, but it's better than allowing that shit to keep happening. That's what it is. So John Ray did Enron bankruptcy. He helped reorganize Enron, and it took time. People are pissed about that, but that's the process. It was also really complicated. So John Ray was kind of the perfect person to jump in and be like, this is a wild system. AKA, they were using QuickBooks for their accounting. Now, QuickBooks is great, but it's not, I run a crypto exchange great. Like, there's different things. Like, yeah. So
QuickBooks
John Ray,
is fine for like your I run a convenience store.
Or multiple companies, but it's not like a crypto exchange. Like, and when you realize that they were authorizing transactions via like instant message with like an emoji, like a thumbs up, like, hey, transfer $1 million, thumbs up. No, bad.
Frowny face.
Carson Pratt still behind already elementary students and guns. Let's not forget the bravery and kindness of the ID teacher that stopped a potential situation with a hug. I haven't. Remember that one. Teachers are phenomenal people, and they get put in situations where I would never put a lot of people into. And I thank them for that. Crazy Cat Queen, courts sometimes forget that people that are financially devastated also sometimes take their own lives. I didn't say that part out loud. I think it kind of goes without saying, but yeah, there's in the wake of the Enron case, there's a whole lot of those reported stories that were really bad to hear. And I imagine FTX is going to have some more. Baby steps. Rob, I love your heart and compassion. Thank you, baby steps. I try not just to be myself the entire time. Happy Annie. Thanks, Rob. Needed FNF tonight. Happy Annie. I'm glad that you were here to enjoy it with us. Baby steps. I don't have ADHD, but I love the tangents. So do I, and so do we. All right, folks. It is 4 hours and 39 minutes in. It is 1 o'clock, 1:22 a.m. Eastern, which means it's what, 11:22 your time.
It's late.
Yes, it's late. It's late for all of us. We're going to go to bed. Thank you for being here. Ian, thank you for joining. Thank you for contributing. And thank you for keeping my sanity while talking FTX and SBF. I honestly could not have talked about that case without you here. And I appreciate the hell out of you for being here. It's
a fun case when you're willing to laugh at it.
And scream at a wall. Either way. Anyways, thank you guys for being here. Thank you to Emily and Alita for showing up in the chat. Thank you to the mods for moderating. You guys are amazing and phenomenal. Everyone, please have a wonderful, wonderful weekend. Sandy coming in as a mod. Please don't forget to like and subscribe with a sparkle fart emoji. Please do hit the like button and subscribe if you like the content. I very much appreciate all of you being here. Have a wonderful weekend. Use the weekend to go out and make something, even if it's making a friend or making someone's life better. It's still making something. So cheers to all of you. And I wish you all a very pleasant weekend. Happy March, folks. March Madness. Cheers.